Does it work? It is working, thank you. Good morning, ladies and gentlemen. I'm very happy to welcome you here on behalf of the organizers of the St. Petersburg International Legal Forum, as well as on behalf of the International Bar Association at this roundtable. This roundtable is dedicated to discussions of... I can speak louder. I will try to do that. Do we have any amplifiers here? Sound amplifiers. Do I begin from the very beginning? So welcome on behalf of the organizers of the St. Petersburg International Legal Forum and the International Bar Association, who co-organized this roundtable discussion of professional ethics in legal profession. Abroad. I apologize that it turned out that we have the hottest room in the building. The air conditioning does not function. But we have an adjacent room. There's water available as well as tea and coffee, and at any time you can stand up and go there. And depending on how well our discussion is going to go, we will make a break, or perhaps we will skip the break depending on how the discussion develops. My name is Vasily Rudomino. I am a member of the Council of the Federal Bar Association of the Russian Federation and a senior partner of Alrud Company. As I said, this roundtable was organized by the Committee on Professional Ethics of the International Bar Association together with the Federal Bar Association of the Russian Federation. What is the International Bar Association? Very brief set of information. This is an international association of bar organizations created in 1947. It is the international leading organization that brings together professional lawyers, law organizations, law firms from all over the world. It is through the lawyer associations, organizations, that we unite more than 4,000 members. There are individual members, approximately 45,000 from all over the world. This year, IBA became the leading partner of this forum. It organized a number of discussions for the forum, including this roundtable discussion on ethics. We're very grateful to the organizing committee that they agreed to include this session into the program, because it is a very important topic for our profession, for the development of our profession. We're also very pleased to be able to greet here representatives of the American Bar Association, because they, together with the IBA, made a proposal to the Forum Organizing Committee that a discussion on ethics should be included in the program. It was decided that the International Bar Association is going to be the lead partner here, but the American Bar Association will be a supporting partner. Using this opportunity, I would like to say a few words about the American Bar Association. This is a national organization uniting American lawyers, and even though it is called an American Bar Association, not only American lawyers may be members of this organization. It may bring together lawyers from other countries as well. More than 400,000 members. That's how many people they have in the American Bar Association right now. And now a few words about the main topic of our discussion. You may all know that in Russia, according to the printed and published plans of the Ministry of Justice, certain changes are bound to happen in a few years. Over the past 20 years, we've seen that more than 65,000 lawyers found themselves belonging to the parts that we call the regulated section, In accordance with the law on lawyers, they are part of one side of the profession, but there's also another side, there's another sector which is not regulated, and they are represented by privately practicing lawyers. They function as limited associations, representative offices of international companies, etc., and private entrepreneurs. I think the situation should be changed, and I hope that very soon, just like in other countries, we will have one corporation that will unite privately practicing lawyers, and that organization will cover everyone who provides counseling and advice on legal matters and who render legal services. Obviously, the changes that are bound to happen within the next 2 to 3 years in the profession are going to be dramatic for the profession. They will require a change in practices, and that will affect not only privately practicing lawyers but also lawyers that are part of law firms. We hope that the Bar Association will be the basis for establishing a new organization. The new members, and I think we will have a lot of new members, we don't know how many members we will have because we have a lot of private entrepreneurs who render legal services. They will have to adopt the existing code. I believe the code will require certain fine-tuning because of such changes, because so many people will become part of the bar. These people, among other things, are engaged in other types of activities compared to what corporate lawyers do, etc. It is no secret that most lawyers are involved in criminal cases and civil cases. So what changes do we expect to happen? We're going to have a very good opportunity today to discuss such issues. We will be able to discuss the most modern trends in lawyers' ethics in the world. What are the trends that we are supposed to take into consideration when making changes to the existing code of ethics? I think it will be interesting for us to discuss the provisions of the code that may or may not meet the existing demand. For example, lawyers' marketing, the restrictions that should be lifted or, on the contrary, made even more rigid. What should be changed in order to create healthy competition in the lawyers' community. So these are the issues to be discussed today. And I think we have a very good team of presenters. Our panelists are, I'm very glad to introduce the first Vice President of the Federal Bar Association of the Russian Federation, Yuri Pilipenko. Yuri is a managing partner of one of the Russian law firms. He's a lawyer, and the law firm is called Just. I'm also glad to introduce to you Geraldine Clark, a partner of Gleason McGrath Baldwin. She is a co-chair of the committee, of IBA Committee on Professional Ethics. She's also a member of the Irish Committee of Appeal on Financial Services. She's part of the ministry group created for working on the code and the law on real estate. Geraldine Clark, over the past few years, has headed the Bar of Ireland. I'm also very glad to introduce Adrian Evans from the University of Monash in Melbourne. Adrian is a practitioner and an academician. He is a member of the working group on anti-money laundering legislation introduction, which is part of the IBA Professional Ethics Committee. Adrian is the head of the Department of Legal Practices at the Monash University. One of his specializations is legal ethics, or ethics in the legal profession. Yelena Krasnikova represents the American Bar Association. She is a PhD, an expert of the Association of American Lawyers. She's General Director of the Consulting Center, Ethics in Business, and she's an expert on regulating entrepreneurship. She is also a member of the Committee of Olympic Games. She consults entrepreneurs and Russian companies on professional ethics. She also teaches a course of legal ethics at some MBA programs in several schools in Moscow. I'm also very glad to see Alexander Nestirienko among our panelists. He is the president of the Non-Commercial Partnership of Corporate Lawyers. Until recently, he was the deputy head of Rosnan Corporation. He formerly headed Unilever in Russia and Ukraine. He worked for the British American Tobacco. He was vice president on legal issues and corporate relations of the International Banking Group, BNP Vostok. I'm also very glad to say that Alexander was a practicing lawyer for a long time and was a member of the St. Petersburg Bar Association. So if the issues that we're going to discuss today are not foreign to her. I think it's high time now to move over to the actual discussions. Adrian, we will start from you. The Code of Ethics, and we have comments to the code as well. It was created in accordance with international standards. Adrian will tell us about the general principles for the legal profession that was adopted by the International Bar Association.
Thank you, Vasily. And thank you also for the welcome this morning. Geraldine Clark and I are delighted to be here. And we're very glad that the International Bar Association will have an opportunity to speak with Russian lawyers today, and perhaps through the medium of the recording, perhaps on later occasions also. We'd like to say at the start that the International Bar Association does not believe that we can necessarily teach anything to anyone. We are here to learn as much as to talk, and that is why we'd be very glad if those of you who would like to ask questions of us as we go, to feel free to ask questions as we go, and not to wait till the end when you forget. Because if you speak as we go, then I think we will have an interesting discussion. We would like it to be interactive. If there are questions at all, I'm sure Vasily will be happy if we interrupt. If not, I'm sure he'll tell us as well. Okay, well, we're going to cover a number of issues today. These are issues which are very live issues so far as the International Bar Association is concerned. I'm sure they're of interest to the American Bar Association as well, and to the Russian Bar. We're going to deal with a number of the so-called IBA principles. There are 10 principles which we're going to quickly go through. Geraldine and I will share explaining what they are very quickly. And as we go, we will try and refer to the principle of the Russian code that most closely connects to the IBA principle in each case. And you'll be able to see later, if not now, which code provision from the Russian code connects to the IBA principle. But we're not going to stop with that. We're also going to discuss, via Geraldine in a little while, the issue of a regulated bar. As Vasily was explaining in his introduction, the IBA does have a very firm view about whether there should be one bar or a division of bars. And we will go into that in detail shortly. I should say perhaps that there are places down here if anyone would like to move down this way. What do you think, Vasily?
Yes.
Yeah.
Yes.
Okay. After that, Geraldine and I are going to conduct some debates between ourselves. So we will argue with one another, I hope in an entertaining way, about what should happen in some key areas affecting legal ethics. The first area is very, very important, and that is whether lawyers should actually be made to pay into a compensation fund to compensate clients when some lawyers steal their money. This is a big issue in the International Bar Association, and it ties into the issue of compulsory malpractice insurance as well. We will cover both those points. And then we'll talk about conflicts of interest, and particularly how difficult they are for the international legal profession, and a couple of other issues after that if there is time. But as we say, we would be very pleased if there were interruptions and questions as we go, so please don't feel afraid to do that. All right, without further delay, we will talk about the IBA principles. Now, there are copies of the principles on your seats for you to take away with you. And these principles were approved by the IBA in 2006 and have since been reissued in 2010 and 11 with an expanded commentary. On the International Bar Association website, you will find these principles and the commentary if you need to look at them later. So the first of the major principles that we think are important to talk about briefly is the professional principle of independence, which relates to the code of Russian Code, Article 5. And Geraldine will explain this particular principle now.
Okay, good morning, everybody. Great pleasure to be here to talk to you. It's my first time in Russia, my first time in St. Petersburg, and my first time speaking with the translation into Russian. So you'll have to excuse me if I say the odd breaks in my sentences which you can't translate into Russian as I go along. But the first principle, the IBA principle, is the one that is very dear, of course, to all our hearts as lawyers, and that is the principle of independence for lawyers as profession. And the IBA Code, number 1, says a lawyer shall maintain independence and be afforded the protection of such independence in giving clients unbiased advice and representation. A lawyer shall exercise independent, unbiased professional judgment in advising a client, including as to the likelihood of success of the client's case. So the independence referred to in the IBA principles, and the first principle is the independence of the lawyer, first of all, from those in power. So the independence of a lawyer as a professional, and then the independence of the lawyer from the client. The IBA principles very strongly state that, while there is an ongoing debate as to the extent to which a government can interfere in the administration and conduct of the legal profession, lawyers and the bars which represent them must strive for and preserve the true independence of the legal profession, and must encourage their governments to avoid and combat the challenges to the rule of law. So, in order to comply with this first principle, the lawyer must be in a position to be objective and free from direction, control or interference of, first of all, the state, and secondly, the client. They must be able to advise in the absence of any improper self-conflicting interest which would impair the lawyer's professional judgment. This implies that the lawyer should not be involved, for example, in the client's business affairs, be a director of the client company or a client's companies, which are the subject matter of the advice that the lawyer gives, or be involved in a relationship with with the client or with the director or employee of a client. And at least the example I often give is the lawyer who is having an affair with in-house counsel in a client corporation. The lawyer is clearly concerned that the corporation remains a client of the firm, but is also aware that in the event that the advice that he gives may not be one which in-house counsel likes, it may have an effect on his affair. So, in a case such as this, can the lawyer be truly independent and give truly independent advice? So this is maybe something that we can debate a little bit later on and you can consider. The wording of this principle is mandatory. So it's not a lawyer should try to exercise independent, unbiased professional judgment. The lawyer shall. So it's mandatory on us. It doesn't give us any option. It means that we have to advise the client, perhaps, that the client has no case at all, in circumstances where we know that if we proceeded a bit further, there would be fees to the firm, which will not be coming if the client doesn't take the case. And this, of course, this principle is inextricably linked to principle number 3 of the code, of the IBA code, which is the whole area of conflicts of interest. So I'm going to leave it just here at the moment, pass to Adrian, and we'll come back to conflicts of interest. If there are any comments at all as we go along, please make them, because we may not reach.
All right. The second IBA principle that we think is important is the principle of honesty, integrity and fairness. Now, you probably think, isn't that just stating the obvious? Because if we're not honest, if we don't have integrity, what have we? Well, we have nothing. Therefore, the question is perhaps a very obvious one, but we think it important inside the IBA to make this principle very clear. It does align very confidently with Principle 8 of the Russian Code, Article 8 of the Russian Code, so it's not new. But we think there are some new things happening in this area that we want to mention. The most important thing to mention is that a principle of honesty, integrity and fairness means that we have to put our duties to the courts before our duties to the clients if there is a conflict between the two. And this is not often understood well enough in many jurisdictions. The IBA is very clear that our principles of responsibility to the court come before our responsibilities to a client. And this is a hard one, yes. In any event, we try to make it very essential. Now, what is happening new in this area is quite interesting. There is some research going on in the United States and elsewhere known as functional magnetic resonance imaging research, which actually attempts to map the way in which oxygenated blood flows around the brain and according to what pathways that blood flows. These particular flows of blood can be mapped to whether a client is actually, or anyone else for that matter, is actually telling the truth or lying or not. A far more sophisticated way than has ever been developed before to give an indication of whether someone is being honest, is being candid, is being truthful or not. Now, this work is in its early stages, but there's quite a lot of reporting already in the scientific literature about the early results. And it's not inconceivable that 5 to 10 years from now, we will have a situation in which anyone, including ourselves as lawyers, will be testable for whether we are lying or not in a particular situation. Now, can you imagine how important it is, ahead of any such developments, that we come to grips seriously with the obligation to be honest in our daily doings with clients? Now, I don't throw this in for any greater purpose now than to indicate that these neurological research agendas are occurring now. And as a profession, we will need to have a response ready for them when they become commercialised, as they will. The third point I want to mention, or the third principle, relates to conflicts of interest. And as Geraldine says, we're going to cover this in more detail in a debate a little bit later on and try and get some disagreement going amongst ourselves in some ways. But for the moment, I think we could just make a couple of comments about conflicts of interest, which are covered quite clearly in Article 11 of the Russian Code, and they appear as Item 3 or Principle 3 of the IBA Principles. So essentially the view is that if you're acting for one person, you cannot pretend at the same time to act for someone else and earn double fees. This is something that the big city firms in the major jurisdictions would like to be able to do. The IBA is very strongly opposed to that because of the risk it gives to our sense of integrity. In other words, how can you represent two clients at the same time who are either in conflict or who may be, in the past, have been in conflict? So that particular principle, as far as the IBA is concerned, is a very, very hot topic because we're constantly getting pressure from the big firms to water it down because it interferes with their business structure model. It interferes with their profit making. We do not regard this as a healthy trend, and we want to talk about that in a little bit more detail later when we get to conflicts in the debate side. Yes, question.
I'm Seifert from Leningrad Bar. So what do you mean by this principle? So representing the interest of two clients in one litigation or interest of related clients in two different litigations?
An excellent question. We certainly say that it is not possible to represent two clients in the same litigation experience. The pressure is coming from the big firms in the second situation you mentioned. They are not saying that we need to have two litigious clients representing by the same lawyer, but they do say that if you have a former client and a current client, then it's possible to represent both. And they want to set up things called, as you may know, I'm sure you do know from your question, the issue of an information barrier. Used to be called in earlier times the notion of the Chinese wall. But more recently, that term is being discontinued because it's considered to be racist. And we now use the term information barrier instead of Chinese wall. So even if you have a Chinese wall, the question becomes, or you have the information barrier, the question becomes, does that information barrier leak or not? And if it does leak, then how can you represent both sides? But as I say, we will come to this question, and thank you, that is a very important question. We'll try and deal with it a bit more fully later when we come to the debate. Is that satisfactory, or do you have a follow-up question, perhaps?
No, thank you.
Thank you. I'll now hand over to Geraldine, who's going to talk about the fourth IBA principle.
Well, you know, it's interesting because this question links into almost all the IBA principles. So the next one is confidentiality and professional secrecy. And the IBA rule says that a lawyer shall at all times maintain and be afforded protection of confidentiality regarding the affairs of present or former clients, unless otherwise allowed or required by law and or applicable rules of professional conduct. Now, this ties in with Article 6 of the Russian Code, with which you're familiar. So it does allow, it's mandatory on the lawyer to keep the client's information secret and confidential, but it does allow rules and laws to be made by governments or by bars which might mitigate that obligation. It's important to differentiate between confidentiality, professional secrecy, which the French call le secret professionnel, and client privilege, which is significantly narrower. In common law jurisdictions, this allows a client to claim privilege over certain legal advice provided by its lawyer. Matters which are protected by legal professional privilege are also protected by confidentiality, but the converse is not true. So the concept of privilege has been eroded considerably in the jurisdictions of the European Union in the last few years by the introduction of the money laundering directives. They have been implemented into the national laws of most EU countries, as you would probably know. And these impose an obligation on a lawyer who has a suspicion that a client may have been engaged in money laundering or any other criminal activity to report that client to the authority, but not to tell the client that the lawyer has done so. So the not telling is called tipping off, and tipping the client off is actually an offence under the legislation. And this legislation has been implemented in my country for the last 10 years, and it has caused a lot of difficulties for lawyers, because it is really very much contrary to what we as lawyers would always have believed to be our position, that if we have information relating to a client, not so much information, but a suspicion, that we must report that suspicion, that client, to the authorities. Now, there are exceptions. The exceptions are in cases where the lawyer acts for the client in judicial proceedings before the courts, or for the purpose of giving the client advice about the legal position. And the question of what that means and how far that goes is a matter of some great debate in Europe at the moment. A challenge has actually been brought by a French lawyer called Patrick Michaud to the European Court of Human Rights in relation to this very topic, and that is before the European Court at the moment. And the CCBE, which is the Council of Law Societies in Europe, has intervened in that. So that is interesting if you're interested in the whole area. But the IBA principle essentially says that it is of the essence of a lawyer's function that we be told things by clients which we will not tell others, and that we can receive that information for and on behalf of our clients on a basis of confidence. Without the certainty of confidentiality, there cannot be trust. And we would say that because of that, confidentiality is a primary and fundamental right of a lawyer. The obligation of confidentiality in relation to a client's affairs is not limited in time, and it applies to all information obtained regarding the affairs of the client, irrespective of whether or not the client continues to be a client of the firm. There is an ongoing debate in relation to the extent to which confidential information given to one partner in a firm can be protected from the other partners within the firm, taking into account the rules of partnership law in many jurisdictions, and whether information barriers can ever work. And then there is, of course, the question, as you raised it, of a lawyer acting for two clients in one matter, or for the same client in relation to a number of matters, or for a former client, for a new client against a former client. And I think all of these are things, with practical situations, which give rise to a discussion around this area of confidentiality and secrecy, and hence around the area of client interest. So we are going to talk about it a little bit more later on. One question?
Can I ask a question about this confidentiality and tipping? Now, suppose the lawyer learns of some money laundering or some acts of corruption involving the client, and he tips the authorities. Now, what happens if the authorities want more information and use the lawyer to ferret out more information from this lawyer? What is the lawyer going to do? Is the lawyer going to be the police, the mole, so to speak, for the client, and keep going on to get more information without telling the client and feeding back to the police as a follow-up to the tipping? What is the position? I mean, how is the lawyer going to act in this sort of situation? Thank you.
Okay. This is a big problem, because when the legislation was being introduced, in my country, for example, the government wanted to say that the lawyer would also continue to act for that client to complete the transaction and then hand his file over to the authorities. And I was president of the local bar, the bar at the time, and we argued that this was a fundamental breach of everything we stood for as lawyers, that we could not be obliged to continue to allow the client to incriminate themselves with us acting as their lawyer. And in fact, the legislation was contained, narrowed, so that now it simply means that if we have a suspicion, we must tell the authorities, not act for the client anymore, but we cannot tell the client why we're not continuing to act for him. So this is a big problem, because if the client is my client and I say, I cannot act for you, and he goes to you and you are my colleague, I cannot tell you why I'm not acting for him, because that would be a breach of my confidentiality agreement with my client. And I cannot tell the client why I'm not acting for him, but I have told the authorities. And what happens then is sometimes the authorities will investigate, of course, and then they have very wide powers. Anti-money laundering in Europe is very strong. Or criminal activity, they're looking for proceeds of drugs, proceeds of crime, mainly. They have power to seize the files of the lawyer, so they can ask for the file to be handed over. So the lawyer is not obliged to provide more information and cannot be obliged to testify against the client. But the files of the lawyer can be seized by the authority for the purpose of investigating further. So, Adrian? Yeah.
I think both I and Elena are going to add something here, but in answer to that question as well, it is crystal clear, very clear, that while we have to comply with the legislation in the narrow sense, if we go beyond that, we are treading into very dangerous territory in terms of our own ethical relationship. Ethics underlie the law. They are not extinguished by the law. So as soon as the law stops, ethics must return. And that is what we have to keep as our fundamental principle. Eliana.
I have a question. And what does the Ethics Committee do at this time? How can it react with regard to the action of the lawyer who stops representing the client? What does the Committee on Ethics do? What's the position of the Committee on Ethics in terms of lawyers' ethics and professional ethics?
Well, you know, we all have one, I suppose, control over our practice as lawyers, and that is we must do it within the ambit of the law. So if the state introduces a law which says that lawyers must report a suspicion of criminal activity, then of course the bar cannot discipline a lawyer for doing this. And when this legislation was being introduced in Europe, there was a huge lobby to the European Commission from the CCBE, from the ABA, from the IBA, and every organisation actually representing lawyers in the world, I think, lobbied the Commission to say this is not good law. But the Commission said, sorry, every other profession is subject to the same obligations. And actually, yes, accountants are, all professions who advise clients are subject to the same money laundering legislation. So the Commission was not prepared to exempt lawyers. But there are exemptions in relation to acting in judicial case. So if I'm acting for a lawyer, a client who is accused of drug trafficking, I don't have to report. or if a client comes and ascertains the legal position. This is the definition. It's not entirely clear how wide it is, because it hasn't really been tested. But to ask me what is my position if I had some money which I got from perhaps importing something I should not have imported. To ascertain the legal position, then I don't have to report. But those are the only two exceptions to the money laundering legislation. It doesn't probably answer your question, but I think the answer is that the bar cannot discipline the lawyer if the lawyer is acting in accordance with the law.
Thank you.
You next.
Okay. Thank you, Geraldine and Adrian.
No, Adrian's next.
You go.
A few more.
Oh, you go? Okay.
Yeah.
Sorry.
Won't take too long. It's all right. Okay. We have lawyers' undertakings to deal with, as well as the property of clients and third parties, competence and fees. Now, there are a lot of principles. These ones will be clear to you, so I'm not sure. Do you want us to go through the rest? All right, we will. So after that one, we come to client's interest. Geraldine, do you want to mention that briefly? Yeah.
This is also tied into the previous one in a way. A lawyer shall treat client's interests as paramount, subject always to there being no conflict with the lawyer's duty to the court and the interests of justice, to observe the law and to maintain ethical standards. So this ties in with Article 8 and 9 of the Russian Draft Code. And of course it obliges a lawyer to act in the best interests of the client. But always bearing in mind that as lawyers we are also public citizens who have a responsibility for the quality of justice. So while that allows us to pursue matters on behalf of a client by taking whatever lawful method is required, it also, the IBA would say, and we would say, obliges us to consider the moral, ethical position. So the question is, if the lawyer says, I want to do this, I just want you as my lawyer to tell me how to do it, and the lawyer believes that what the client is going to do is not ethical, does the lawyer have an obligation to point this out to the client? We would say yes, and that the obligation is to try to get the client, to persuade the client to take the ethical route rather than just deciding to do something which they can do. No client ever wants to be told that they cannot do something. So this is a difficult, serious challenge for us as lawyers, I think.
And the sixth principle is the principle of a lawyer's undertaking. Now, interestingly, this particular principle does not have a parallel provision inside the Russian Code at all. It's one of the few principles that is not mentioned in the Russian Code. And this principle says that each of us as lawyers will honour any undertaking we give to anyone else in the course of our legal practice until the undertaking is performed or relaxed or excused. Now, by an undertaking, I essentially mean a promise. If we promise to do something in a way that's accountable to someone else, then we are bound to complete it, whether we want to or not. These undertaking principles are an expression of personal honour. And the concept of personal honour is important to the legal profession. It's not an out-of-date term for us as lawyers, no matter what sort of legal practice we have. It's central to the value we give society and to the rule of law. So I suppose the summary is never give a promise to anyone else unless you intend to carry it out. And most especially, do not give a promise on behalf of a client unless the client has already authorised you in writing to give that promise. And that's the reason for this particular principle in the IBA Principles. Geraldine, number 7.
Number 7 is client's freedom. And it says, a lawyer shall respect the freedom of clients to be represented by the lawyer of their choice. This is unless prevented by professional conduct rules or by law, a lawyer shall be free to take on or to reject a case. So it's the right of a client to choose the lawyer and the right of a lawyer to refuse to take on a case. It's an acknowledgement that if a client wishes to instruct somebody else, that client must be free to leave your firm. The duty of the lawyer is to make it as easy as possible for the client to do so. And this is often not easy for us to do as lawyers, because if we feel that we have done a good job or that we are doing a good job for a client and the client wishes to leave, then obviously it's very difficult. And sometimes, of course, the big issue is the issue of fees. And what is the right of the lawyer in relation to unpaid fees? Can the lawyer say, I'm not allowing you to leave until all the fees are paid? In some jurisdictions, the lawyers have a lien, a hold over the file until all the fees are paid. Not just the fees relating to this particular case, but all fees. So, for example, in my jurisdiction in Ireland and in the UK, lawyers are entitled to hold the client's files until all fees are paid. However, the ethical rules of the IBA and our ethical rules will say that we must not cause any significant disadvantage for a client by holding on to a file. So that while the law strictly says I can hold the file, the ethical practice dictates otherwise. If, for example, the client's case is coming up for hearing and the client requires the file must be released. So the client is free to leave without too much problem. It's a bit more difficult, of course, for the lawyer, because once you have accepted instructions as a lawyer, once you have taken on the client, it's very difficult sometimes, and in some jurisdictions almost impossible, to cease acting unless there is a good reason. And often this conflict arises where a lawyer has given advice to a client that the client does not have a very good case, perhaps, and the client does not wish to accept that advice. The client then wants to move to another lawyer. The lawyer wants to stop acting because he feels he cannot continue to represent the client. But if he wants to come off record for the client, he must make an application to the court. In making that application to the court, he cannot tell the court why he no longer wishes to act. Because, of course, he cannot prejudice the client's case by saying in a public document to the court that he has given advice which the client doesn't wish to hear. So, I suppose in practical terms, rather than ethical terms, as lawyers we must be very careful who we take on as clients, because it's very easy for the clients to leave us, and it's not very easy for us sometimes to leave the client and to do so in a way that's ethical.
Okay, Geraldine, thank you. Question? Great.
You made a very clear explanation about how the lawyer can try to refuse a case during when the process has already started. But when you have a first meeting with the client at the very beginning and you don't want to take on the case, you want to refuse the case, do you have to explain to the client why? Because of course you can say that I'm too busy, I have too many cases and I just cannot take on this case. But in principle, do you have an obligation to explain? That's my first question. And the second, with regard to the file, you said that you will give the file to the client in any case if even if the fees have not been paid. But how does that agree with the ethics? Because this is your job. You have already invested something into this work. That's your intellectual work. Why do you have to give the file to someone and not keep it?
Yeah. Okay. I think there's a lot of questions there. I think you should be up here too. I think what's important to bear in mind here is that the underlying principle here is that the lawyer is a professional as opposed to a mindless servant. We have an obligation to look after the principle of professionalism when we're interacting with our clients. And if we feel the need to say to a client, I don't want to act for you because I'm not comfortable with our relationship, you should say that and not be anxious about it. If the client is unhappy with that response, so be it. That's how it is. If the client is not someone you want, then why does it worry you if you are that candid? If you are very straight like that and you don't want to keep that client, you're not rude to the client. You don't have to be rude or offensive or impolite. You just say, I'm not comfortable with our relationship and I don't wish to act for you. End of story. I know Geraldine might like to add something as well.
Well, I would just say that your client only becomes your client when there is a retainer. So if you're talking to somebody who is asking you if you will take on their case, technically they're not your client. Now, you could say you still may have an obligation, to be polite and all that, but until the retainer has been agreed, they're not your client. I would say that's the answer to one. Now, the files and the transfer of files, I think it is difficult because, of course, if you release the file, you probably won't be paid. But on the other hand, the courts will hold, well, in many jurisdictions, if it comes to the court will hold that the client's case cannot be prejudiced by virtue of the fact that the file is being retained by the lawyer. So it's a difficult balance. You can sometimes deal with it by giving as many documents as are strictly necessary. And I think sometimes it can be unfair on the lawyer. But equally, I think Adrian's point that the lawyer is the professional, we have an obligation not only to the client, but we also have an obligation to the rule of law and the interests of justice. And it's a matter of balancing those with our own interest, which is the interest to be paid our fees.
Thank you. Спасибо. Я хотел буквально на секунду.
Sorry, I have one question actually on the lawyer's honesty. Of course, as a matter of principle, if the lawyer is very honest, I think much of these principles will be subsumed under that. The trouble is, in some criminal lawyers who need business, what they tell the client who comes to them is that, oh, I think you have got a pretty good case. And the moment the case is accepted, then along the way, he will tell the client later, I think you should plead guilty because you have a lousy case. So then he collects his fees, you see. I mean, the thing is, it's a business. Law is a business. To grab the client in first. Never mind, it may not be that honest to start off with. But later on, you can be very honest with him and tell him, oh, you have paid my fees, basically, and now your case is not good. Let's plead guilty. And he saves a lot of work himself, but he collects the fees. That's point one. Then the point two, as a judge myself, we normally hear parties submit on costs. And the two parties may well know that if I were to reduce the other side's in submissions, the other side's level of fees, next time you do the same to me. So if I invite the parties to submit on costs, both sides will submit on relatively high costs, as to what they should be paid. And the judge, when you hear that, it's a bit difficult if you have to decide what should be the amount, the quantum, because you have to base on submissions of the parties. I mean, if you say, okay, this matter, okay, $20,000, but the client, the other side will say, I think if I were to reduce it too much, the next time round you do the same to me. So the lawyer, the court is really sometimes in a dilemma. What are your comments on all this? Thank you.
Well, to take the first point about the lawyer who wants to get in the client, so therefore lies to the client and later on says that he's got a lousy case. I mean, that is the most short-term, stupid strategy of any criminal lawyer. Very soon his approach is known to other people, that he will mislead the client for the sake of getting the job. It would take a year or two before this word gets round. But I've had cases like that in my own practice in Melbourne, where this type of lawyering is the starting approach for many, many new lawyers especially. And what finds out that within a year or two their reputation is known, and the number of good cases coming to them starts to decline. Or the judges, as you would know yourself, sir, start to realise who they're talking to in court, and that the person they're talking to in court is one of those slippery lawyers. Therefore, they believe less what they're told by that sort of lawyer. So I don't think in the long term the strategy that you're talking about works. I think it fails in the long term. But in the short term it does work, and I don't have an answer to it in the short term. The longer term issue regarding how you manage the fee situation, I don't have an answer. I don't have something that's satisfactory to you, I don't think. I've often thought about this myself. I can't see the way out of it in a straightforward way. Geraldine may.
No, I don't think there is, but I think there's one thing I just also maybe add before we move from the topic, and that is, of course, there is an obligation on a lawyer to immediately cease to act for the client if the lawyer knows that the client has perjured themselves, or if the lawyer has made a false statement which the client intends. The client has made a false statement which the client will not withdraw and which the client intends to submit to the court. So there is a positive obligation on a lawyer in a case like that to withdraw. And that raises the same kind of question as we talked about earlier in relation to money laundering. So it's just important to mention that, I think, before we move on.
I'd like to use my right as the moderator to break, or rather to jump in to this discussion, because I think that we have a person here who is very dear to the entire community, Sisan Kommunikashvili. Sisana is the president of the Scientific and Methodological Center for Mediation and Law. We met yesterday at the forum, and I said that I am going to moderate this session, and Sisana said that she wanted to come and make one comment, which is very relevant to what we're discussing now, because she will have to leave for another discussion very soon. So I'd like to offer the microphone to her.
Thank you very much, and I'm sorry for interrupting you because your discussions were extremely interesting. But I have to come back to the round table where I am a moderator. I just wanted to mention that today the mediation, the alternative settlement of disputes, is getting more and more important in legal profession. Do we like it or not? Do we consider mediation to be our competitor, which is not true in my point of view? Mediation can only be a good help for the lawyers, and may inspire the upgrading of their professional qualities and become an extra tool available to the lawyers. But using the opportunity and in the framework of your topic, which is the ethics for contemporary lawyers, I think that a contemporary lawyer must have knowledge and competence, and to offer the clients other types of settlements, such as mediation, among other things. And I think that in the code of ethics in different bars. For example, I saw it in American Bar Association. I saw a provision obliging the lawyers to provide information to their customers about all possible types of dispute settlements in addition to litigation, and to help the client to make a choice, an informed choice. First of all, I call to the attention of Russian lawyers. And not so long ago, we have an organization who will take care of mediation and help that together with Russian Federal Bar, we shall try to incorporate this provision, this issue into our Russian Code of Ethics. I wish you successful continuation of your very interesting and heated debates. I think it was a good statement, interesting statement.
I think it was also an interesting statement. And I think that most lawyers in most bar associations around the world would now agree that mediation techniques, alternative dispute resolution, are an essential part of legal ethics. Yep. And the fact that they're not mentioned specifically inside the IBA principles probably means that they should be updated, but they will be in due course. I'd just like to mention a couple of other principles now briefly. I'm aware we have been sitting for a while and that everyone's hot, especially our valiant interpreters. But I think I'd like to just mention these ones briefly so that Geraldine will be able to finish up on fees. The two important principles here are Principle 8, the property of clients and third parties. Now, this refers to the importance of us as lawyers keeping our clients' money separate from our own money. This has not always been well understood in different bar associations or different legal practices, but it's a recipe for the lawyer actually stealing clients' money over time unless they keep them separate. And not only keep it separate, but the International Bar Association is also of the view that we need to help their clients earn some interest on the money that we keep separate from our own money. And by that I mean that if the client's funds are significant, then the interest on those client funds that are held by the lawyer for a reasonably lengthy period of time should perhaps be considered as the client's money and not the money of the lawyer. If this principle is ignored, then we also become careless of what is really in our client's interests. And so we need to be remembering this. So Principle 8 refers to that. There is no close approximation for that principle in the Russian Code. Article 16.6 of the Russian Code speaks about the need to keep clients' funds separate from our own funds, but does not talk about what we do with clients' money when we have kept it separate. So I'd just like to suggest that to you, that the International Bar Association is moving in this direction, and that informs one of our debates after the break in relation to how we should treat clients' money in detail in terms of the interest especially. And Principle 9 is the principle of competence. Now, you know, one would have thought it was a basic principle that you don't need to specify, that everyone who calls themselves a lawyer should be obviously competent. But it isn't the case. There are many lawyers the world over who are not competent. Now, you might say that a competent lawyer can't survive very long, but let me assure you, it can take only 2 or 3 years for the lack of competence to be known. but lawyers who are incompetent are also often unethical. The two seem to go together. And if they are both incompetent and unethical, they become very good at hiding their lack of competence. So we want to make it clear that there is a need to look after competence on a serious basis. And the way the international profession is moving to do this is to introduce compulsory professional development for lawyers at intervals after they enter practice. This is now becoming very common. And so, for example, if you're not prepared to undertake between, say, 10 and 20 hours per year of compulsory re-education around your own area of practice, and including compulsory re-education around ethics, then you may not have your practicing certificate renewed. Your license to practice may not be renewed. This is increasingly a serious undertaking by the world's professions, including the legal profession. I'll hand over now to Geraldine for the final principle, which relates to fees.
Well, of course, this is probably for some of us the matter dearest to our hearts, isn't it? The question of fees. And the IBA last principle, the last one, mind you, of all the IBA principles, is that lawyers are entitled to a reasonable fee for their work and shall not charge an unreasonable fee. And finally, a lawyer shall not generate unnecessary work. Now, Article 15 and 16 of the Russian Code deals with this. And I suppose, you know, as a lawyer in practice, and as all of you know, probably the issue of fees is the greatest single cause of dispute between lawyers and clients. And we wonder why. You know, is it because the client doesn't understand the added value that a lawyer brings to the work? Or is it because we as a profession are not very good at dealing with the question of fees? I mean, I think some lawyers are actually embarrassed to talk to clients about fees at the beginning. It's not quite that they don't want to, they just don't want to talk about it. And the IBA, it says very clearly that the criteria for dealing with fees and how the fees should be charged takes into account the nature of the assignment, its difficulty, the amount involved, the scope of work to be undertaken, and then any other suitable criteria. And we would say that that is the basis on which fees should be explained to clients. So from the outset, the client should be told that this is how the fee will be charged and calculated. More and more, in practice, fees are charged by, I think, lawyers across the world in terms of cost per hour, billable hours, and what can be billed. And I think that is why the principle of the IBA says that a lawyer shall not generate unnecessary work, because there is undoubtedly very wide scope for unnecessary additional work to be generated in cases where fees are charged only by reference to the amount billed. Not necessarily so easy to do it in the other case, where the breakdown is given to the client and it is explained to the client that the importance of the work, that the importance of the advice that the lawyer gives, the scope of the work to be done by the lawyer, that all of these are factors which should be taken into calculating the fees as well. It's something that I think we, as a profession across the world, have an issue with, legal fees and how they're charged. And I also believe that it is the one area in which we as lawyers are at risk of damage to our reputation as a profession. There is a sense that lawyers' fees are too high, and we must wonder as a profession why this is the case, why people who do not complain about the fee that their consultant medical practitioner will charge, or their dentist or anybody else will charge, or even their accountant, but they will complain about lawyers' fees. So I think this is a big issue for the profession, and it's a big issue for the bars, and particularly for regulated bars to get right, so that there isn't, so that members are entitled to be paid, lawyers are entitled to be paid what is reasonable, but without this perception that there is unnecessary work being generated or that unacceptably high fees are being charged for the work which we do.
Thank you. Thank you, Geraldine and Adrian, for presentation of this of IBA principles. Спасибо за презентацию принципов IBA. Мне кажется, очень важно для
I believe it's important for us to understand how those principles were elaborated, how they were designed, and what's the current status, how ABA is updating them continuously. I already mentioned that IBA was established in 1947, and initially it was an association of bars. And till now, bars are the key strategic players in IBA. There is a council that unites 149 bars from all over the world. So first of all, those principles are drafted by the Committee on Ethics, and afterwards all IBA members review and comment on this draft. So the final document is the outcome of a joint work of all global lawyers. So it's a consolidated opinion of the lawyers community in the whole world. We already mentioned today that community of lawyers are represented by individuals, but private lawyers and by bars. Geraldine, I would like to ask you to tell us a brief how, let's say, the bars are developing today in the world.
I won't cover the whole world, you'll be delighted to hear. Not every country. But more and more, I think the profession is moving to the view that the bars should be regulated, and where possible, membership of the bars should be mandatory. And why do I say this? The purpose of the bar is twofold. First of all, the bar is the voice of the members, the individual members of the profession, the representative voice of the profession. A united bar, to which all members belong, make it much easier for the president of that bar to make representations to government, to interface with government in relation to legislation which is being drafted, in order to put forward the views of the bar members, both as representatives of their clients, but also as citizens and as good citizens and good representatives of the public interest, in the public interest and the rule of law, the interest of the rule of law. If the membership of the bar, if the bar is seen to be regulated and the membership of the bar comprises all of the practicing lawyers within the bar, then that voice is undoubtedly much stronger. Because if you go to government saying we represent only part or a small or a proportion of the lawyers who practice, then your voice is not so strong. The second function of the bar, of course, is as regulator, either as sole regulator in some countries, as in my country. The bar is regulated by the Law Society, by the governing body. So it's a representative bar, it's also a regulatory bar in relation to minor matters of conduct. But in relation to more serious matters, it is co-regulation with the President of the High Court, who has the ultimate sanction to strike a lawyer off, to refuse a lawyer consent to practice. So many countries, in the UK, in Australia, there is an independent regulator, but that independent regulator should comprise a large component of bar members. And who appoints the regulator is a matter of big debate. And Adrian, I know, has strong views about this. Whether, if the membership of the regulator, if the majority are appointed by the government, can it then be said that that is in fact independent? If the majority is appointed by the bar, then is it independent of the bar? And how should the balance be struck? So that is, to answer your question, Vasily, Mr. Chairman, that is where the debate is going at the moment. In my country, we have draft legislation which will take the regulation away from the bar and appoint a new regulatory body. And we are arguing now as to how that representation on that body should be. But almost certainly, there cannot be, in my view, a regulator which does not have representation from the bar, strong representation from the bar. So this is another reason why, if the bar is united and if the bar is comprising the members who practice, all the lawyers who practice, then it's stronger. If you don't regulate all of the people who practice law in your country, if all lawyers are not regulated, then it leads to very serious difficulties, because many lawyers who practice in other countries are not regulated at home. And I can think of some countries where there is very little regulation. We all know the lawyers from that country go to practice in another country. If they cannot be regulated in the country in which they practice, and they're not regulated at home, in their home jurisdiction, then who regulates them? So.
Спасибо, Sven. Меня зовут Frank Engelmann. Я был президент регионального палата Brandenburgia. И моя вопрос была...
Here's my question.
Госпожа, мы в Германии
In our team,
об этом.
In our team, we often talk about this, and even today I say this, that a lawyer and a lawyer's work is needed or not. We usually discuss issues such as whether it's good or bad. And the same is happening in Russia. We stand for the professional liability, for the professional work of lawyers. So in our team, we also discuss whether or not we need at an upper level any ethics rules. We know that lawyers don't really need it. This is why in our bar we work with the law. We work within the law, we don't work with the ethics. That may be a problem. You can work without ethics or ethics code, but then you need to have a law on that would regulate this professional activity. And I think this is related to our discussion today. IBA
Regulation это для нас профессиональный закон.
For us, it is professional legislation. This is not about ethics. Thank you. I understand that it is a statement, not really a question. Melissa, please.
Geraldine, you touched on this. I just wanted to ask you to address it a little bit more directly. And the situation where you have a voluntary bar association, and so membership is not mandatory, and therefore regulation is not mandatory, and how a country might cope with regulating lawyers in that situation. For example, the United States has a voluntary National Bar Association. Thank you.
I think I might actually ask the question back to you, because I know that the International Bar Association feels very strongly that it would be a stronger organisation in terms of representation if it were mandatory for members to belong. And in fact, it's a criticism that has sometimes been levelled at the ABA, that it doesn't in fact represent all the lawyers in America. They have a regulation system which is federal, so the individual bars within the United States have regulatory functions. So it's not so much, I think, an issue on a global US problem of regulation, because they have individual regulation as well. But I know that it does, and then maybe Elena would know as well, but the ABA can speak for themselves, but I think they do feel that they would be stronger if they were able to say they represented everybody.
Спасибо. Ну что ж, после такого подробного обсуждения principles.
Well, after such a detailed discussion of the principles, of the ABA principles, and after our associated discussions on the topic of what's happening in the professional community, I think that it is high time to move over to Russia and to focus on Russia. It is my pleasure to give the floor to Yuri Pilipenko, who is not only the first vice president of the Federal Bar Association of the Russian Federation, he's also the author of this wonderful book. It is one of the first publication, very detailed publications of comments to the Code of Ethics. Yuri, the floor is yours. Thank you very much. I was anxious to grab the mic and say a few words. While I listened to my colleagues, I realized that, thank God, we have the Lawyers' Inquisition. And we have inquisitors as part of the IBA who will not leave us lost, who will not let us lawyers be lost in this difficult world, and we will always be able to find the right answers to the questions that we face on a daily basis. And I'm very glad about that. A few words about the Russian reality, or at least the way I see it, in terms of ontology, in terms of the practical implementation of the principles. At this point in time, we have a code of ethics, and I took a copy with me, although I'm not sure that all Russian lawyers, I don't mean those present here, of course, but I mean my colleagues, we have approximately 70,000 my colleagues in the country. I don't think they actually read it very carefully. This is what it looks like. It's a very small booklet. Obviously, it has a lot to offer. The content is very complicated, and I brought my book not just to boast of it, but to show the difference in the volume between this little book and the comments. I wrote the classical commentary, the way people write commentary to the laws, because this is a provision, there are different opinions, there are different interpretations, but I wanted to show you the two books here in order to tell you that as an author of this book can be criticized, and I have some criticism to offer. I have to say that this is a very important document for the Russian lawyers community. It has been in existence for 9 years, and I think it made a great influence on the corporate thinking and corporate self-regulation. We have to understand that there are 70,000 lawyers in Russia. Over the 9 years that we applied the principles of the code, there were 5,000 people who were stripped of their license because they breached the provisions of the code. These are the people who we did not want to be colleagues with because we believed they did not maintain the principles. I don't think this problem has been resolved fully. I believe that we still have a problem of quality, and we still experience a need to clean our ranks. I recently spoke at a lawyers' event, and I said that the code of ethics that's been around for 9 years was supposed to meet several goals. One of them was to protect the lawyers from the possible pressure of government authorities, such as tax authorities, etc. And I believe that we have completed this goal. We have reached this goal. There are some singular cases when lawyers were stripped of their status or disciplined in some other way for their professional attitude, for the stand they take in courts. We very rarely have such cases. You know of the UCAS case. It's a famous case. Everybody knows about it. And I should say that the lawyers who took part in this case, there were various petitions about all of the lawyers in this case, petitions requesting to strip them of their lawyer status, and none of them were. So I think we can be proud of that. However, I believe we are entering a new era, and we have to be prepared for a paradigm shift. It's time when we should be prepared not only to defend lawyers, but the bar, the community as a whole. I believe that it is important that we introduce a new term, a new notion of the business reputation of Russian lawyers as a community. I think it is also of specific value, and we as representatives of the bar should be defending this reputation. What I mean here is that today we have a very difficult technology for starting a process in terms of disciplinary process, because when there are three types of response to such a disciplinary process. One is a comment, the second one is a warning, and finally a stripping of the status. It's very difficult to see the difference between the first two, actually, a comment and a warning. And sometimes you don't know whether you have to warn a lawyer or comment on his actions. However, if you strip the lawyer of the status of license, then it's for life, because we know no legal document contains the description of how this license can be renewed. So if the lawyer had his license taken away, then it's for life. In the criminal code, we have such a measure as to ban for a certain number of years somebody's practicing a certain profession. But that's for several years, whereas with lawyers, what happens when you strip the lawyer of the status of a lawyer, then it's forever. I'd like to give you an example. It's a very famous case, a scandalous case, I would say, and possibly for the Russian colleagues, it would be old news, but it could be really new to our foreign colleagues. I think that if we had not had that case, we would have to think it up. One concerns a lawyer with the name Miller. It's public information, so I do not hesitate in pronouncing this name. A few years ago, we had a scandal involving the first prime minister of the Russian government, Mr. Shuvalov. And the foreign mass media, the Financial Times specifically, published documents that showed that he showed some insider information to gain some riches. This was never prosecuted. This has never been investigated. Later on, some information was published with regard to the fact that all the documents on this undertaking, on this dealing, were given to the lawyer by the name of Ivlev. He never denied that he did that. On the contrary, he was very cynical about saying in the internet that he had reasons to not reveal these documents, and he had some explanations. He said that Shuvalov was not his client because they did not have an agreement. He acted as self-defense. I have to correct, he did transmit these documents to the mass media. He said that Shuvalov was not his client. He said that the law and the moral law is higher than the interests of the client. I think it was quite cynical of him to say that. And on the same day, we got information on the web with regard to the fact that the Moscow bar did not want to discipline this lawyer because there was no application from the client. And I looked at the situation with the eyes of an ordinary person. I think there's something wrong going on, because we have people in this who have no knowledge of the code of ethics. In fact, some lawyers have very little knowledge about that. It should be clear that if you give some documents to your lawyer, the lawyer should not give these documents to the mass media, even if 5 years or 10 years have passed. So when things like that become known, and then a person who a lot of people respect in the profession, the representative of the profession, says that there's no reasons to start a disciplinary hearing, I think for all of us find themselves in the mix, because we see that there's nothing happening, that nothing moving forward.
Well, the second example, about 2 years ago, one of our colleagues said that we need the courts of Shariat in the Russian Federation, and if somebody objects to these courts of Shariat, they, obviously the Muslims, will start a bloodshed in the city and turn it into a dead lake. It's horrifying. If somebody talks to me or to my colleagues about the courts of Shariat, it's an issue for debates, and we can discuss it. We can always discuss whether courts of Shariat are good or proper for Russian Federation. But if a blackmail is following, a blackmail of blood shedding, it's really kind of a sign of a mental disease, and I don't want to see this person in the ranks of our lawyers. Well, I think that these people should live somewhere in the wild mountains, not in the civilized community. And now we have a dilemma. Whether a chairman of Moscow bar initiates a disciplinary case, and we again heard those, let's say, strange statements that this was stated aside the professional behavior, and we can take into account only those statements that were done in courts or in some legal circumstances. I really don't like this situation. I do object strongly to such attitude, and I think it's high time to think about the honor and the dignity of our profession. And I started this discussion to initiate debates on the following issue. Whether the compliance to the moral and ethical principles a must for a lawyer. Let's say whether moral and ethical values are inherent parts of the legal profession. Well, I understand that this is quite a questionable issue, that there are different viewpoints. So everything which is outside the professional duties is not subject to the discussion. So we can judge only about those statements and behavior and conduct that was demonstrated within the professional life. So we cannot say anything if it was done in a way of private life. So I would like to hear about the other experience. So if in a private life a lawyer, let's say in the United States, did something that was against the moral and ethical principles of this profession and really damaged the reputation of the lawyer, is it subject to punishment, to disciplinary consequences? I understand that in Russia we may have a different situation, and maybe the complete planting of American experience in our country is not possible, but I think that it's important question to be reviewed, to be considered, and maybe at our next Congress of lawyers we will have to introduce alterations into the code, because the code is adopted only by professional community. This code does not need any registration, endorsement, or any other official execution. So I suggested the following alteration. For example, to grant the right to the chairman of the federal bar. Today, this federal bar is not a part of disciplinary cases. It's done on the regional level. Presidents and vice presidents of regional bars might be directly or indirectly involved in such cases. I suggest to grant this right to the chairman and vice chairman of the federal bar to initiate the cases to protect the honor and dignity of a legal profession. I understand that this definition is a bit vague, but again, in our code, we don't give a list of particular violations of professional ethics. It just gives principles and definitions. And actually, only 15% in our code referred to the ethics itself. The rest is the rules of conduct for lawyers. I also believe that we should extend the range of possible sanctions to lawyers. So, if we don't use such a sanction as a temporary suspension of the license or the legal lawyer's status, we will not go very far. So this a very big difference between the warning and withdrawal of the license does not give an opportunity to our community to react properly on the misconduct of our lawyers. Just an example, grave misconduct was done by a lawyer. He acted as a witness against a criminal case of his client. So his license was withdrawn, but later on he actually came crying to the bar, pleading that I'm 15 years in this profession, I know nothing else, I have 3 small kids, I have to feed the family, so the withdrawal of the license was replaced by a warning. And I think that was not very relevant as a punishment. If we would have a temporary suspension of the license, that would give more opportunities to show and to take into account the gravity of this misconduct. And I think that we have to, if we don't want to change a federal law, we have to introduce a new term such as disqualification from the period from 1 to 3 years. Of course, we will have to get an approval from the Ministry of Justice, but I believe that my ideas are correct. I also want to add a rule into our code of ethics that would stipulate that a lawyer must comply with moral and ethical rules. It is put else where I already named them, that saying that the rule of law and integrity is above the interest of clients. So let's say today we can refer to this rule that if you don't have a contract with your client, you can always make reference to the provision of this code.
I have a few more ideas, and there are several approaches possible. First, we need to write a new code of ethics, and we might have to do that, but in long term. It is possibly going to be a necessity when we finally will get the monopoly for the lawyers representation in court, and second, when we will get rid of the dualism in our profession, because a lot of people who practice law are outside the bar, and they may have their own views on the content of the code of ethics. However, I should say that I don't know a single celebrity or very big person among the lawyers, because we hear a lot about lawyers not being very professional. We know that some lawyers may be greedy, they ask for too much money, and you can say a lot of other things about lawyers. There's a lot of criticism that is flung over at the lawyers, but there are some very known people of significance who are known in the world. However, I cannot say that I know such people among people who are not part of the bar. They are only trying to earn money, and that's the only thing they do. So I really doubt that among people who are not lawyers we may find some reasonable comments about the code of ethics. Some time ago I took upon myself to finish every presentation by saying that Carthago should be destroyed, and Carthago in this way would be the dualism of our profession. Let me just say a few words. So what's the difference between the practicing lawyers and practicing legal professionals? The lawyer should have a degree in law. By the way, some of the legal professionals, they do not have such a degree, and things like that happen. But in order to become a lawyer, first you need to have at least 2 years of practice, so that you can show that you need to have some experience. They understand what the law is all about. Obviously, this is not something that applies to what we call legal professionals who are not lawyers. Lawyers are supposed to be able to pass a very difficult qualification exam, several layers of exam, several levels of exam. I know that in some of the regions, half of the candidates do not pass such exams. Lawyers are supposed to subscribe to the code of ethics. In fact, they say an oath, and some cynicists may say that the oath does not matter, that there are just 10 words that person has to pronounce, but I disagree. I believe that every word materializes, and that lawyers take an oath is important, and that makes them different from the so-called legal professionals. Lawyers are it's their duty to improve their qualifications, and I know that in some regional bars they have a rule as to how many hours they have to spend a month in order to improve their qualifications. There is some responsibility that lawyers have. So there are a lot of significant differences between lawyers and non-lawyers. Lawyers may be good or bad. There may be very highly qualified and not very highly qualified lawyers. But this is an institution. And I keep saying that we should be maintaining and promoting the development of this institution rather than the development of separate individuals. And so this is what I would like to finish with, and saying that Carthago should be destroyed. Thank you very much, Yuri. Is there a question? Once again, Zyfer, I'm a lawyer. when such changes are introduced into the Code of Ethics and the heads of the federal bar would be able to start the disciplinary actions, do you think there would be a pressure against the lawyers? Just take the UCAS case. Some of the lawyers were too good and they interfered with the prosecution's plan. They stood in the way of the courts, etc., etc. Do you think this would be a leverage against lawyers? Thank you for the question, and if you had not asked that question, I would probably have asked someone to do that. I think lawyers all over the world are excellent people. All lawyers in the world have something in common. Very rarely, lawyers are interested in details. And let's talk about details now. What's happening? The right of the chairman of the federal bar to start a disciplinary process does not mean that it will end on a positive note. It would only mean that the chairman can start this process, but the local or regional qualification committee of a regional bar may refuse to take it up. So the chairman would have to think twice or even 3 times whether or not his petition would be taken on and what the response would be to this petition. And that, in fact, produces another element and strengthens this so-called self-regulation of lawyers, because you have feedback, you have a two-way street. Today, the chairman of the federal bar is like the English queen, so far removed from the regional bars, and this would give us a two-way communication channel, because the pressure would be there, obviously, but the pressure is there today, because if you look at the vice president of the regional bar, the vice president of the regional bar may be able to start the disciplinary action. But I think this new element, this new introduction, this new amendment would help change a lot of things, would be an additional instrument. And again, just as I said, it does not mean that there will be sanctions decided upon in the end. So thank you for your question. In his presentation, Yuri said that it turns out not all lawyers know what the Code of Ethics is all about, even though they have a lot of experience in applying the main principles of the Code. And we know that 5,000 people had that license taken away from them, and that's a lot of people. But I feel that not only among the lawyers, or not so much among the lawyers, but also among our clients, we see that there is a lack of understanding that the Code of Ethics exists. A lot of our clients, and we probably can divide our clients into 2 groups. One is individual clients, and the second group is corporations or companies. And as I said, Alexandra Nestirienko represents a very big part of our clients, corporate lawyers. Every day they contract with us and they receive our services. And I would like to get some feedback from corporate lawyers. What do you think about our ethics code? Have you ever heard that there is such a code? Alexandra, the floor is yours. Thank you very much. I represent the Association of Corporate Lawyers, Russian Council of Corporate Association. There are a lot of names to it. We are talking about lawyers who work in different companies, who are legal counselors. They are part of legal services of different companies, small, medium, or large. It was rather unexpected when Vasily called and asked me to be a panelist here. I didn't even know what I was getting into, because I had to prepare for today's discussion. Let me say a few words about what Yuri said earlier. I was deeply touched by what he said. I think he touched some very important chord in my heart, because for over 10 years I worked at the Leningrad College of Lawyers. We only had 500 people at that time, and when I joined the ranks of this organization, I was so happy. It was the happiest day of my life. I joined the elite. it was only then that other colleges came to being, that other associations were formed, but I still feel part of this community. I still feel very much a lawyer, and my father was a lawyer, so I feel myself as a lawyer, even though I am legal counsel. I work in-house. So I'm wearing two hats today. I asked a few questions to the heads of legal departments of big corporations. They responded to my emails, even though a lot of them were on vacation. We had holidays, and some of them gave me very lengthy descriptions of what the ethics is all about. They said this comes from the Greek ethos, accepted traditions, following the moral principles, and the initial idea behind it was cohabitation and rules that regulate people living together. They talked at length about what ethics is all about. But I asked the question, what is the ethics in the legal profession? What is the lawyer's ethics? I got the following responses. They usually said, well, for me, the lawyers or legal professionals' ethics is an integral part of the profession. And that's what Yuri mentioned earlier on the topic of ethics. If a lawyer is not ethical, then he is not a professional lawyer. That was one of the responses. Another person said something very similar. In fact, there was a lot of things in common. If you are a professional legal advisor, you have to abide by the code of ethics. Now, in terms of lawyers' ethics, I had a lot of responses too, and some of them really surprised me, and in fact, some made me very sad. The code of ethics does not work for lawyers. Another director of a big legal department said, I never actually met with lawyers' ethics. And then he said, a smile, put a little smile next to it. Another person, another head of a big legal department said that lawyers' ethics is something very unrealistic, ephemeral, something that you can only find on paper. The fourth person said, well, if the lawyer gets his license away from him, then he would not be able to exercise the ethical principles. I asked other questions, whether or not the lawyer's status is important when choosing a legal counselor, when you want to get some consulting. And I thought actually that it was important. But a lot of people responded saying that it is important when you are looking for a criminal lawyer, because this is where the functions of a criminal lawyer are very clear. In other cases, they said, here's what they said actually, when we are looking for a consultant, we don't look for a lawyer's status. Because first and foremost, we're interested in their professionalism, in their experience, and not membership in some kind of a lawyer's organization. The only I asked questions of this kind. So an in-house lawyer, an in-house legal professional does not care about the code of ethics of lawyers. It's not the main criterion. And so the main ethical principles are already part of the contracts that are developed by large firms, or if necessary, we can include such principles in our contracts with legal professionals. And the only thing we would like to see exercised, the only rule, the only principle we want to be there is the confidentiality of information. But it is already part of the federal law. And in fact, many agreed that the interest of the corporation is often higher than the principles of the code of ethics. So the reputation of a specific person is more important than the fact that this or that person abides by the code of ethics. So that was quite surprising to me. We also talked about whether or not the code of ethics should exist in-house, whether or not in-house lawyers should abide by the code of ethics. I was also very interested in finding what people say, because we tried to introduce some kind of a code of ethics for in-house legal professionals, but we did not get very far. And a lot of people told me that no, in-house counsellors do not need a code of ethics because they have to abide by the code of ethics of their companies, of their respective companies, because every big company has a code of ethics for its employees. A lot of foreign companies do, some of the Russian companies do. There are a lot of different rules, you have to comply with them, etc. At the same time, in many cases, discussion was veered towards another matter, because if a code of ethics applies to in-house legal professionals, then you have to get into another conflict area, abiding by the law, even if it goes against the expressed will of your client. And so we talked about the lawfulness of legal professionals' actions. How can one work as a lawyer and be a good lawyer? How can an in-house legal advisor can work? For example, an in-house lawyer gets paid by the Director General because he reports to, for example, the head of his department, but sometimes directly to the Director General. And so if the in-house legal advisor sees that the company violates certain laws, if the documents go against some legal provisions, should the in-house legal advisor initial or approve the contract that violates certain rules? And the answer is obvious, no. But how can this person continue to work in the company? I had a lot of colleagues who found this topic very topical, very important, and they came up to me and continued the discussions. So how can a modern legal advisor in-house ensure that the company abides by the law and the internal documents and internal interests do not come in conflict with the law? So this is again a topic that we discussed at length. And finally, a question, the final question that I sent, whether or not all professionals in the legal area should have a code of ethics. In-house legal advisors, prosecutors, investigators, etc., etc. And I had answers that could be divided 50-50. Some say yes, definitely yes, because it is important in order to have the rule of law. Others said, at the same time, they said that it should not be limited to a document that would exist and would not be enforced. If you have a code of ethics, it should be enforced, and you should teach people how to enforce it. For example, the first lecture in every law school should be dedicated to the discussion of this code of ethics, because medical professionals all take an oath. What about the legal professionals? So the ethics should be part of a curriculum, and a lot of people said that. But if there is no will in terms of enforcing the code of ethics, then every code of ethics would first generate surprise, and then there would be people laughing at it, and then it will be forgotten. So there should be an intense effort focusing on the code of ethics at all levels. I think that's what Prime Minister Medvedev said, at all floors, so to speak. At the same time, that there should be separate code of ethics for several different areas. That's 50% of all the responses, and there were another 50%. I'm not going to tell you about some categorical responses which stated that it's not time to talk about the code of ethics while the whole system is up in the air, the whole court system and all of its elements are not quite clear. And there are a lot of problems with it. We should introduce a big code of ethics for all the system. A lot of people said that the introduction of a code of ethics is not reasonable, because all specialists have different tasks to complete, have different functions, although there are a lot of principles that are in common. So what are the arguments against a single code of ethics? The arguments are as follows. If there's a code of ethics, there should be control mechanisms and taking people to be held responsible. There should be a mechanism of that. They say that the present mechanisms are not functioning. And actually, I think a lot of people do not know about how the Code of Ethics works, because this is the first time I ever heard that 5,000 people were stripped of their licenses. And I think it is a big problem. Maybe very emotional, too emotional, but I can see that a lot of legal professionals in big companies never actually faced any ethical problems and never met with ethical principles, because I disagree with it. I know a lot of lawyers, I know a lot of very good legal professionals in Moscow, in St. Petersburg and other places. These are my colleagues who for some reason believe that they have never met with that. I asked them to give me examples. I disagree strongly.
So actually, half of my respondents, it was about 20 people, stated that they don't see the need to introduce a common code of ethics. Actually, what they meant that it was just a paper and pencil document, not applicable, not practical. So the common wish can be expressed by a phrase that I would like to quote. Well, legal counsel in banks are exceptionally skeptical. So this during May holidays, I put one of my respondents contrary to the other, so they started to quarrel in writing. So actually what he wrote, we all one and the same thing, the rules of the game that will protect us against fraud and lies and make us feel secure. Well, you draw a frightening picture. I see that there are a lot of questions that follow up your presentation. Irina Grebneva, lawyer. I think that the code of ethics is needed. If it would have been perfect, federal bar should have suggested those non-regulated lawyers to join to the rules of this code. So let's say if the reputation of legal community would create an obvious competitive advantage, we would be able to invite more and more non-regulated legal firms to join this code and to become members of the bar. Today, the bar says we want to be monopolist. Maybe instead of insisting, it's better to invite. Today, it's hardly possible because the code in its current version does not provide sufficient security protection, and that prevents corporate lawyers from joining this code of ethics. So instead of contradicting each other, we'd better share each other's views. Thank you. Do you have a comment? You are absolutely right saying that our code is not perfect. Just to reiterate once again, our lawyers, our bars were mainly directed to criminal cases, and that's a stigma that we still have. I think that sooner or later we shall eliminate the dualism in our profession. And already today in the federal bar we decided to draft a new code that will be appropriate when this dualism is eliminated. So, if you have good ideas, if you have good codes, what's wrong in the current code, we invite you to join our efforts and to provide your comments and your contribution into development of a new code. We will try to incorporate all valid comments into a new version. Just recently, I participated in a discussion attended by American Bar Association, and we discussed the need in the ethical code for non-regulated lawyers. I'm against it. I'm against it. If you want to. No, I did said the same. So before we make any code, we have to unite such lawyers, and secondly, if they are not regulated lawyers, how can we ensure the compliance? So it shall be really just a paper. So Irina's proposal is causing my skepticism. So I'm not sure that somebody willingly, by its own initiative, will join our code. But how are we going to control whether they are following the ethical rules? No, it must. I said that it must be important for the client. Well, as we have already heard, some clients said that there is no need in any code of ethics in our country, and I think that's really the major challenge. And I know that there are some opinions both among in-house lawyers, private lawyers, and so on. So there are state beliefs that our country has not yet reached the state when the code of ethics makes sense.
I was simply going to comment on what Yuri said in relation to the sanctions and the availability of sanctions. And whatever the code is, you have a code which is a working code, which is a good code. Some people feel it needs to go further, but I think it's really important that the bar be able to sanction breaches, because there is no point in having a wonderful code unless the sanctions are available. And I think your point, Yuri, that the only sanction that's available ultimately is a strike-off for life, seems to be, in the overall context internationally, extremely draconian. And in a way it may be, I think, as you said, counterproductive, because ultimately, unless it's a really, really serious breach, the sanction that somebody would be prevented for life from practicing is dreadfully draconian. So if you had the possibility of having less serious sanctions, like a censure, or, as you suggested, a strike-off for a couple of years with a possibility to come back, then it's much easier to have the bar enforce that. And of course, what the IBA tries to do is not to come in to here or to anywhere and say, our code is better, or we are the ones who should tell you what to do. But it is in a supportive role, that if the local bar, if your bar or the Irish bar or the Australian bar wants to make representations to government that certain things should be changed, or that the powers of the bar should be changed, and the IBA is in a position to support that, then in my experience that gives the local bar much more weight in expressing an opinion to government. So it's not just the opinion of the Russian lawyers or the Australian lawyers or the Irish lawyers, it's the opinion of the International Bar Association, which represents the global voice of the legal profession as well.
Adrian, что ты хотел добавить?
I'd just add one thing, that the global trend is not to have just a single power to strike someone off or cancel their practicing certificate. In fact, there's a wide range of penalties are now normal, including initially a reprimand, which is published on a website, and so the lawyer knows and everyone else knows they have been reprimanded, but they're allowed to keep practicing. Okay? And then you have 6 months, 12 months, 1 year, 2 years cancellation of license, and then you can come back to practicing. It's very rare that someone is completely prevented from ever returning to practice. And so that's the global trend. Thank you.
Thank you. Спасибо.
Вот меня удивило, конечно, то, что юристы корпоративные не знакомы с
Well, I was really surprised that in-house corporate lawyers are not aware about the code of ethics, because in any let's say, legal software that are commonly used in our countries, you may find the abstracts from the cases of the Moscow courts and the Moscow bar, and there you can find references to these disciplinary cases, to the application of the ethic codes. And why non-regulated lawyers are not willing to be, let's say, united? Well, on the one hand, the in-house corporate counsel usually are very specialized. They know a bit of law, while a lawyer, the general practitioner, let's say, must know law as the whole set of different rules. I would like to use my position of a moderator. We do suffer from the lack of awareness of our clients about the legal services. And we are speaking not about the clients from corporations, but we are speaking about the clients represented by the CEO or top managers of these corporations. So they don't know what is the legal ethics, what is legal confidentiality. They really miss this knowledge, and that's why they don't realize what are their rights and duties as customers of a lawyer. And I think that federal bar does not make sufficient efforts to promote this knowledge, to spread it. So, because I wish to come to the following situation, that a client will tell my boss did not allow me to hire a non-regulated lawyer, because it means that we have a very close link between fiscal violations, antitrust violations, and criminal punishment. And this punishment will most of all apply to the owners of corporations, not to their legal counsels, and that must be understood. Ivan Sliptsov, Pravo.ru. I have the following question, and I shall start with the comparison. We all know that there is a disciplinary prosecution. Well, this disciplinary commission became quite an open organization, and the reports my colleagues make from the hearings of this commission are getting more and more popular. About 3 months ago, I spoke with a judge, and this was a disciplinary commission against a judge. The judge said that I'm going to appeal against your decision, but the head of this disciplinary commission said that you may do whatever you want, but do mind that this information will become public. So we have journals with the abstracts from the hearings of disciplinary commission, but people really do not have the information that 5,000 lawyers lost their licenses, and I think that this information is important and significant. So I'm coming back to my questions. Do you think that meetings of disciplinary commissions of lawyers must become public and open? The judges already gave us a good example. They showed this example of transparency. Maybe lawyers will follow their example. If I can get any feedback, I would be grateful. And in-house corporate legal counsel about their understanding of ethics. I think that among in-house councils, there is an opinion that ethics is not yet suitable for our country. And what is appalling that usually they are pleased with the absence of these ethical rules, because this lack of morals allow in-house counsels to go to courts and to win the cases that are absolutely unethical. Today, when the legal cases are getting more and more open, and we can get open information about appeals, it's quite obvious that the position of the plaintiff is not ethical, and it's the abuse of law. But his evidence was dubious, and it's not clear how it was accepted by courts. I completely disagree with that statement. I understand that we don't have to stuck on this matter of in-house lawyers, but I completely object to the statement that in-house lawyers are pleased with the absence of ethical rules. There are outcasts in every profession, but don't have to level each and every. You are asked for a feedback. I actually don't mind to the presence of the mass media at the meetings of our disciplinary commission, but with two preconditions. Well, first of all, we have to take into account all circumstances and all relevant issues. And secondly, this is the matter to be addressed to the regional bars, not to the federal bar. And I'm ready to admit that not all of my colleagues are ready to be so open to mass media, but I undertake the obligation to contribute to the higher transparency and openness. I was just prompted that in many cases this presence will not be possible because we have legal secrets. So at many of such meetings, the information pertaining to the confidentiality of the client and so on will be discussed, so they cannot be made public.
I can see Albert wanted to ask you a question for a long time. Well, I know that there is some food served behind me, and I will try to speak louder. A few moments to offer you a comment. As always, when we start discussing these issues, we are diverted into other areas altogether. We are talking about the in-house counsel and lawyers. They're all egocentric. They all follow their interests. In this, with this approach, there's no talk about ethics at all. There's no place for ethics in this conversation, because we have to understand that ethical climate, just like normal climate, does exist. This is a reality that we have to live with. And in the community of lawyers and community of counsel, there are people who are very ethical and follow the principles of ethics, and there are also people who are very unethical. And this is a division that exists. The third point I wanted to make, when we talk about a single public contract between the members of the profession, which is called the Code of Ethics, we have to understand that Aristotle has thought it all. And this public contract can only come into existence when there is a lot in common between these people. So we will only have a single Code of Ethics if there's a single or same regulation of these two sides of the profession. There will be such a regulation because it will come from something that the humanity has already thought of, something that we have had for many hundreds of years, and these are the same principles. You have to understand that the Code of Ethics exists and flourish only where there is a professional community. Until we have this community in place, we will not have a proper Code of Ethics, because only the presence of this community makes it possible to have this public contract in place. And it only makes it possible to take disciplinary measures and disbar the members. And another division, another point I wanted to make, and there's something that we may have a continuous discussion. By way of a comment, I have to say that I am a lawyer. I became a lawyer because I am convinced that it's important. I am a member of the bar, so I agree with Yuri. But again, this is the fourth point that I wanted to make, and it's again a very clear division, and it has to do with the law on lawyers. It deals with the fact that we have to add amendments to the lawyers' law and provide additional advantages, additional functions and additional rights to the clients of lawyers. For example, it's not only about the primacy of lawyers within the context of criminal procedures. Everybody knows that there is such a thing as a lawyer's investigation. This is something that does not exist in this country. If a lawyer, for instance, does investigations inside a big corporation, then the results may and should become the reason to start the criminal case if the lawyer has a corresponding status. If this investigation, however, is done by the lawyer, and then the client finds about it, legal forensics, that's what we call, then the prosecution can say that the lawyer and the client were decided to keep this away from the court. So what I want to say is that the client should have some economic or monetary rights and have the right to act against those lawyers who do not comply with the Code of Ethics. Well, I think we have just touched upon a very interesting area, ethical issues for in-house counsel. I would like to hear from Yelena, who's been working with corporations for a long time. She has to deal with corporate lawyers on a daily basis. So what are the problems that you face when you provide consulting to Russian companies on the issues of ethics? Dear colleagues, I graduated from the philosophy department, specializing in ethics, and I wrote a dissertation on the methods of ethical research. I went to the States 3 times and wrote papers on the morality of education. I think I came to understand, to a certain degree, the system of managing, regulating of ethics in the United States. I think that some elements of this knowledge can be applied in the course of providing advice to various companies that become my clients. I also apply this knowledge when I read a course of lectures on the ethics of business, on the corporate social responsibility. I read such a course in several universities of Moscow as part of their MBA programs. So what are the issues that companies usually come to me with? Why is it that companies need to have advice on ethics? Let me give you some comments on terminology. I heard someone say that Russia has not yet developed enough to be able to have ethics or to afford ethics. I'd like to explain something, because the Russian researchers and the international community says ethics, and means that ethics is something that explains and prescribes certain rules, and these are the rules that are prescribed by morality. This is something that we have inside us, our understanding of what's good and what's bad. So ethics is something that conceptualizes these ideas, something that regulates the sphere of morality. So in any case, for us, we always develop some ethical concepts for ourselves so that we could live our lives. We have certain professional principles that we uphold in our everyday life, and companies try to do the same in their business activities. And why is it that companies need ethics? Why is it that they need advice on ethics? What are the issues that they face that they have to deal with ethics? I decided to divide their problems into 5 categories. As I see it, there are 5 groups of issues. Number 1, the professional community or a company wants to be ethical. So for them, ethics and morality is part of the overall picture of the world. It's part of their integrity, it's part of their life, and they cannot imagine their life without feeling themselves right. Sometimes these are owners of large businesses or medium businesses. They want to invest into the development of certain codes of ethics. The second group use ethics as an instrument, a tool of management, an instrument in to fight competition. For example, they may want to develop an alternative code of ethics to try and find their place in the market. It's actually a very good idea, and I, as a specialist in ethics, can only welcome discussions, because the more people discuss ethics, the more society understands that society is not just a power of nature. We need the society to think about itself. It needs to conceptualize what it does. It needs to explain its actions. it also can be used, ethics can also be used as a marketing strategy by some companies. The next group, number 3, is this: ethics as a challenge, a risk. For example, a Western partner makes the Russian company adopt a code of ethics. Otherwise, they don't want to extend a loan to them. And then the company rushes to develop and publish a code of ethics. And then they try to get as much time as possible from the Western partner to be able to at least prepare their staff to adopting this code of ethics, because that definitely usually leads to a certain change in practices. I think that the adopting of a national standard, ISO standard on corporate responsibility, this has become quite a headache for companies and for in-house counsel. It is based on an international ISO standard. There's a lot of ethical principles in this standard, and a lot of companies have to go this way and integrate ethical principles in their practices, in their corporate culture, in their policies and strategies. One more group, ethics as a business. This means that the company renders services in terms of ethical audit. And number 5, ethics as part of the profession, an element of professional activity, a necessary precondition. As you can see, ethics is very diverse, and there are a lot of different ethics. And what we talked about is covered by these 5 groups, I believe. The 5 groups, 5 scenarios. The lawyer's ethics, professional ethics, could be seen as a business, as a means to maintain reputation, etc. I'm not going to go back into these discussions. So what is it that we can borrow from the American experience? I tried to somehow crystallize my own experience and come with certain recommendations. What I like about the United States Code of Ethics is the nature of the way ethical processes are regulated in the United States. The system is very clear, and separate parts exist as separate modules. When I provide consulting to Russian companies, I'm able to work with separate modules, which are in fact separate parts of a chain. Policies, rules, infrastructures, departments on corporate culture, corporate ethics, etc. By the way, international advisors on ethics recommend not to say ethics too much. Instead of ethics, they say you have to say the right thing to do, the good thing to do, and the best practices. They say that this word traumatizes Europeans and Asians. They say that by avoiding this word, you will avoid making a very grave mistake that some people make. And in fact, that's what our employees often do. So foreign consultants and some of our managers say ethics all the time, and it generates an ironic response, or even hysterical response on the part of those who are listening to them in Russia, for instance, because they believe that the attempt to regulate the morality is something that they can laugh at. They don't want to talk about this too much. This, by way of a recommendation, there's a very interesting bulletin that is published by the International Institute of Ethics in London. They have a headquarters in London. They have a very good professionals from all over the world, and they help to develop training programs on ethics. They offer boilerplates for codes of ethics, because morality and that is being regulated by ethics, this is something that needs to be done, but it has to be done very carefully. We don't want ethics to be a source of conflict. The terminology of ethics should not become a stumbling block. I think a lot of professionals in the area of ethics have a big headache trying to explain for people who are not philosophers by education the ideas about the difficulty associated with ethics and the productivity possibly associated with the ethical terminology. The philosophy of morality, the morale of philosophy. So these are the terms they prefer to use. And these are the terms that my colleagues use in the international community.
The second that I do admire in the American system in ethical regulation are the guidelines. That is called the applied ethics. In US universities, there are centers for professional and applied ethics. That means that there is a distinction. The professional ethics is viewed as something that stems naturally from a profession, from a professional consciousness, and applied ethics is a set of tools, a set of procedures that can be used not only by philosophers but by representatives of any other profession. Unfortunately, in Russia, this set of tools or this set of guidelines is just at the early stage. I was invited by Moscow University to develop a set of guidelines of applicable ethics for those professionals that sometimes change complicated moral issues. And I also like this system of training, system of education in US because it's extremely logical, it's sustainable. During 1 month, I visited different classes. So this system consists of 3 parts. Is the values, the notion of values, the understanding of values, and its a tolerance to other values, and personal development. I think that this experience can be very helpful in the development of different codes. Just not so long ago, I faced an issue when programs of business ethics, business compliance are not properly understood by our legal counsel, who are used to the, let's say, strict control and strict supervision. So compliance actually is a prevention of risk, mitigation of risk. So these objectives may not be properly understood or met unless Russian legal advisors not, let's say, educated properly, unless they understand that these are more preventive actions, it's rather risk prediction, risk prevention measures, consulting to of employees rather than punishment and persecution. There are softer integrity programs, and usually Russians don't have any problems of understanding them. Once again, we sometimes face the problem of proper wording and, say, proper adaptation into Russian language. Another aspect that I would like to touch upon, speaking about American experience or experience of other countries with well-developed codes of ethics. Sometimes a company are just replicating codes of ethics and make, let's say, employees face them, while employees are not yet morally ready. They don't have the required moral standards to comply with that code of ethics. Let's say an employee participates in bona fide, pro bono programs, and a person is not, let's say, well estimated for these efforts. It's a personal achievement for a particular individual, and the management says, you must do it, it's your obligation. It's not that you've made an effort and you decided to do well, but it's your obligation. Any say foreign codes should be taken with caution. Thank you, Elena. On behalf of Yuri Pilipenko, I would like to apologize for his early leaving. He has a plane to Moscow to catch. In the framework of this session, we planned to open a discussion on 3 or 4 issues. And additionally, we were having a coffee break in mind. I think that we have already abused your attention because we are speaking for more than 3 hours. What we still have on our agenda? Do we need to establish special funds that can be used to compensate the damage of clients? These are the funds replenished by contributions of lawyers to compensate the damage of clients. We also wanted to discuss the recent trends in the understanding and settlement of the conflict of interests. Another topic for discussion is in which cases and how and when lawyers must report to the authorities about the suspected money laundering or other criminal activities of their clients. So that were our suggestions, and we are ready to start the discussion. So if you are ready to go on, we can start the discussions. Or if you would like to get a cup of tea or coffee, I suggest you to make a short trip to the adjacent room to pick up your tea or coffee and come back. Alexander, you know that you are participating in another round table. Yes, I have to leave, though I wish with all my heart I would stay with you. So the first question, as I already mentioned, is the need and the appropriateness of special funds. So, in fact, bona fide, reputable lawyers are just collecting the contributions to compensate the damage caused by, let's say, bad lawyers to their clients.
Okay, well, the topic that we are going to discuss now, and we're going to argue, and we would like you to take part in the argument, because Adrian and I are going to start it on two topics. This is really two topics, and they're two separate things. The first one is malpractice insurance, whether lawyers should have malpractice insurance, which means that if I, as a lawyer, make a mistake, an honest mistake in the course of my practice, whether I should have a policy of insurance which covers me in the event of a claim by the client, so that if I make a mistake, the client makes a claim on my policy of insurance and the client is compensated for my mistake. The second is slightly different, and that is a bond, a compensation bond, which would compensate client of a lawyer whose money has been stolen by a dishonest lawyer. And the first is a policy, the insurance, which I would pay for myself to cover my own, we call it negligence, but my own malpractice, my own fault, in the event that I make a mistake. In the second case, each lawyer in the bar will contribute an amount of money into a fund, and that fund is used to compensate the client whose money has been stolen. So why would we do this as a profession? And for the purpose of this debate, I am arguing that we should have both. And we will do it in short form, and we will expand then. Why do I say we should have both? I think that it is one of the major things that sets us apart as a profession in Europe, where this is compulsory in every jurisdiction. It is the one thing that we as lawyers have which no other profession has. So I can say to my client, I can say to the public, I can say to the government, that we are so convinced that we have a properly regulated profession, that we regulate our bar members, and we have an interest in regulating our bar members, that in the event that any one of them takes money belonging to a client, we, as the honest members of the bar, have contributed to a fund which will mean that that client is never out of pocket. So nobody can say that they went to their lawyer, they gave their lawyer money, and their lawyer took that money, and therefore all lawyers are crooks, or all lawyers are dishonest, or the profession should not be trusted. We, as a profession, say we have this fund, so nobody is out of pocket. That's in relation to the fund to compensate for dishonesty. In relation to me and my practice as a lawyer, why do I want to have professional indemnity insurance? We call it professional indemnity insurance, it's malpractice insurance. The first thing is, I can sleep at night when I have it, because I know that if I make a mistake, and I believe that everybody in the course of their lives makes a mistake, no matter how good I am, there is going to be something that I get wrong. But because I have my insurance policy, I know that if the client suffers as a result of my mistake, the client will not lose out. The first thing is, I know I won't be sued. and have my personal assets taken. But the second is, I know my client will not be at a loss because of my mistake. And as an ethical lawyer, that's very important to me. I can be happy that I, by contributing to a policy of insurance, can make sure that my client will not lose out, will not be damaged as a result of my mistake. So in the two instances, my argument, Mr. Evans, is that it is in the interests of the profession. It is a moral imperative, which is something I read in one of your books, that this should be available to clients of the legal profession. And it is in my own interest as a lawyer that I have my insurance so that I can, as I said, sleep at night knowing that my client is protected and that I am protected against a claim where I have maybe no assets to meet that claim.
Thank you, Geraldine. Now, for purposes of our debate, I'm going to give her a hard time. I'm going to disagree. But I don't want you to be upset, Geraldine, by what I'm going to say. Not too much, anyway. So I think the fundamental problem with compulsory malpractice insurance is that it's a very whiny, childish sort of thing to do. That, in fact, it's not... Mistakes go wrong in all parts of life. We all make mistakes all the time. And it's not fair to ask a lawyer to have to compulsorily compensate client just for a little mistake. I mean, really, is it? These happen all the time. Why should we be given such a hard time about it? That's the first point. I think you've completely failed to answer there, Geraldine. So next time, maybe. I think the next point to make is that if we do make it compulsory to have insurance against mistakes, in other words, malpractice insurance, it's going to be very, very expensive because we make a lot of mistakes. And we'll be having to pay out premiums, very high premiums, all the time to insurance companies. And are we going to pay for that ourselves? No. What are we going to do? We're going to increase our fees to our clients. And it'll make our work less available to our clients because it's just going to cost too much with these insurance premiums. So I think there's a cost effect here that can't be ignored. Also, I think that if we're going to have such insurance in the case of effectively a dual profession, as Yuri called it, where we have a regulated profession and an unregulated profession, what will mean is that the regulated profession will have insurance and be more expensive than the unregulated lawyers who do not have to have insurance, and they'll be cheaper and they'll get a competitive advantage against us. And that's not good. If there was a single profession in Russia, that might be different. But until there is a single profession in Russia, I think this is going to make us more expensive than it should be. So I don't want to ignore that one. Also, I think one of the problems about having insurance or a client compensation fund, but I'll come to that in a minute, just the issue of insurance, is that it actually makes some lawyers more vulnerable because some clients are not very honourable people and they will challenge us if they think we've got malpractice insurance, whereas if they did not think we had it, then they wouldn't bother. So it might make us as lawyers too nervous to do the right thing for our client because we'd be so worried about being sued by a client who knows they can be paid from compensation. So there's another issue here. If we're going to act fearlessly in the interests of our clients, particularly against the interests of the state, it's going to be hard to challenge the interests of the state on behalf of those clients if we've got insurance. Because, in fact, the state might manoeuvre the insurance policy in such a way that it did not compensate us, because the state is a very powerful thing in all countries. And I think the final reason that I would put up in favour of not having a client compensation fund, in other words, for when our clients steal from us, is the issue of honest lawyers and dishonest lawyers. there are only a few dishonest lawyers, and when they do steal money, they seem to steal an awful lot of it. And they make it really hard for the rest of us. And why should we, as honest lawyers, have to pay into a fund to compensate the clients of dishonest lawyers and get those dishonest lawyers off the hook in some way? And I think that's morally unfair, that, in fact, dishonest lawyers should be allowed to have a safety net, whereas paid for by us honest lawyers, which doesn't actually necessarily stop them from stealing anyway. It just makes them make them feel as if they can steal more effectively. So I know this is an emotional issue, but there are cost problems for us if we have insurance and cost problems for us if we have compulsory client compensation. So for that reason, Geraldine, you're completely and utterly wrong.
Докладчик не говорит в микрофон, поэтому не могут перевести. Модератор тоже.
Что думает аудитория?
Yes, Geraldine wants to know what the audience think about it. I will start with an issue that is more simple, with the creation of a fund. I think we should have it, but it should be used for specific cases only, not to cover for the risks of dishonest lawyers, but for cases when this loss has resulted not because the lawyer wanted it, because we are all mortals, and it may happen that an honest client, honest lawyer, is providing a quality service, but he or she dies. And of course, I think that from the ethical point of view, the client who got some damages because of that should receive some kind of compensation. I think it is only ethical, and I think this kind of fund should exist. In terms of insurance, I know that there were a lot of people who were against the compulsory insurance for car owners or drivers, and a lot of people said that it was going to be too expensive, it will not work. However, it does work, it does exist, and it works. And we only have problems for insurance companies who are forced to pay a lot of money, which they didn't expect, obviously, at the very beginning. So I believe that for an honest and ethical lawyer, it should be clear that there should be such kind of professional insurance. Perhaps not mandatory, perhaps it should be voluntary. And there are a lot of advantages to that. And I think there are a lot of principles. If I uphold the ethical principles, I will join this insurance. I will buy an insurance policy. And the company, just like in case with the car insurance, the insurance company would not let the lawyer abuse this policy. So I think this is what we should have. There should be a voluntary insurance and the compensation fund for specific cases. Thank you. I would disagree with the representative of the merchants, as she says. From the point of view of an abstract client, it is easier for an abstract client to feel that when the service was not high quality, it is easier to address an insurance company, because that's what people do. Because that's what people do when they have issues with their health, with their cars. They have more experience in this. So it is clear what to do when one wants to get some damages paid for by the insurance. So if you have incurred some damages to your health, you go to an insurance company. The same goes about the car, and the same should be true about the lawyers. As to the fund, we're not discussing the amount of compensation, right? And this may be key to it, because the insurance company, whenever a client applies to an insurance company, the rules are clear. Whereas with the fund, things are still very unclear. You may stipulate, you may in fact develop a big fund, you may actually establish a fund, and it may have a lot of money, but possibly that the corporation will protect the interests of the members of its corporation. The community will protect its members, and there will be no payments to the clients. It is very difficult. So for an abstract client, I think the presence of or the involvement of insurance companies is going to make things easier. The clients may not even know about such compensation funds, or maybe the clients will find out only when their rights are violated. As to the issue whether it should be mandatory or voluntary, I think it should be a voluntary thing, but it could be stipulated by the lawyers as part of their marketing strategy, for instance. I think the lawyers should be able to talk about it and to be able to advertise this. Professor Stoica, the Law Department of the St. Petersburg State University. I'm going to draw upon not so much my academic experience, but my experience as a legal professional and a person who is involved in the protection of human rights, as a human rights specialist and the person who is part of the bar. I have seen cases when dishonest lawyers incurred their activities resulted in damages to their clients. So I would tend to agree with Geraldine's position. But at the same time, it may seem that it may be too early. And obviously, lawyers' corporations, since they have code of ethics or some ethics principles, they may make certain decisions. And why not? But at the same time, the state of our community is such that one has to think first about the, so to speak, how should I put it, the cleansing of the ranks. Because when I make some explanations to lawyers, I see that some of them have been working for 15 years and they cannot quite formulate the question. What is it that they want? And I say, okay, I will formulate the question for you. I also found myself in situations when there were dishonest clients. And sometimes I got into situations where I had dishonest clients and dishonest lawyers. And I sometimes had to defend the dishonest client, even though the clients were to blame. So why do you use the services of lawyers who make dishonest offers, and then you feel that you have been used, and it's difficult to help in such situations? So it is also possible that there is no problem at all. If we have a community of professionals, if the community is very professional and is accountable to the public, possibly the public should be more involved in the activities of the bars, then perhaps the problem will not be as acute as it is, or maybe it will not be. It will cease to be a problem. Because why don't we decide to cover our risks from our pockets? Why not? We earn enough.
If I could just clarify one thing. The idea of the compensation fund is not that it is an insurance policy. It's a fund which is built up. It is usually built up by the bar, by contributions to the bar, and then it's administered separately, but independently of the bar, but away from it. It's not an insurance company. So the idea would be that all the client would have to establish is that money had been given to the lawyer which had been misappropriated. So in order to be paid, it's actually a lawyer who steals clients' money. It's positive dishonesty, misappropriation of clients' funds.
Thank you for this comment, thank you for this explanation. But I think that there may be cases when the funds will not be given to the client whenever there are some problems. So there may be some situations of that kind. So I say that I think there may be cases like that. That's what I wanted to say.
Professor's point that obviously if a client gives money to a lawyer where the client knows that the lawyer is not perhaps a very upstanding member of the bar, or there's some implication, the lawyer and the client are implicated in some deal that goes wrong, well, obviously in a case like that, the client would not be entitled to compensation or the money back So there may be cases, you're right, there may be cases where it doesn't always, but where the client is innocent, the idea is that the fund would pay, with the ultimate benefit that the client can never say that his money has been stolen by a member of the bar and he has been out of pocket as a result.
Vasily, could I just add briefly or quickly that the reason why these funds have been brought in all over the world is that when big thefts occur, when big money is stolen, it's headlines everywhere. And we suffer enormously when that happens. And there's no way out of it. And we can't say a single thing while we do not have a compensation fund in existence.
I can say that it was news to me that such compensation funds exist, but I also found it new that in Japan the free legal assistance is funded by the lawyers, that is by the bars. So that's what gets funded from the government, by the government here. And in Japan, lawyers make contributions in order to fund various activities, including pro bono. Okay, and we have another very important issue to discuss. I think it is of great interest, the conflict of interest. We have touched upon it briefly, and we had a very brief discussion about it. Let us get back to this conflict of interest. It's a huge area, and it is not discussed enough in Russia. It's not researched enough in Russia. It's a whole area of standards, of practices in the legal profession. And both Geraldine and Adrian promised to tell us what's happening in the world in this area.
I will start. Thank you, Vasily. So the conflict of interest issue is probably the biggest global problem confronting the legal profession, excepting maybe two things. That's money laundering, which is a very big issue as well, and becoming bigger and very much on the radar of governments. And also the issue of stealing clients' funds. We've covered that already. But after that, conflicts of interest are such a problem because clients and the community who observe us acting for two clients at the same time are nervous about us, or become nervous about our ethics. They wonder if we are preferring one side or the other in our advice. Now, I know you realise this, and I know this is not a new discussion, but there has been a great deal of subtlety brought into the discussion in recent years because of this issue of former clients and current clients. We discussed earlier today about there being no problem at all if you've got two clients on either side of the same litigation, where there's a complete ban and will always be a complete ban for a lawyer acting in that situation. But where you have a former client who's gone away from your office, no longer a client of yours, you may retain some confidential information about them. And a new client comes along and you discover that that new client has a potential conflict of interest with the interests of that old former client. The pressure is on then to act for the new client and just disregard the fact that you have acted for the other side in the past. Now, if that's the case, the mega firms of this world, the very big firms in Tokyo, or some in Tokyo, increasingly in Shanghai, in Australia, in the City of London, in New York, are all very keen for bar associations the world over. And I'm sure pressure will come onto the Russian bar in this area, if it hasn't already, to allow an information barrier to be set up. So Geraldine and I actually have the same view on this issue, that those information barriers are a problem. And I just want to give you a little example about why they're a problem, for very mundane reasons. A few years ago in Australia, we had a very large firm, a very successful firm that was a bit slack. I'm not sure what the Russian word for that is. frivolous, I don't know, not very caring about the issue of conflicts of interest. So what the firm was told by a particular judge that there was a partner in the firm who should not act for an old client because that partner knew too much about that old client. So the firm was, put that partner in a different floor of the building and pushed him away, basically, and said, well, you stay out of the way and we'll go and act for the other side without you being involved, and there will be no problem. So their approach to the information barrier that was being set up was simply to move the partner who knew too much to another floor. They had a principle which said, oh, well, you're not allowed to go. If you're a member of the staff, you're not allowed to go and talk to that partner at all. And everyone even had to sign confidentiality and undertakings that they wouldn't go and speak to this partner who knew too much, because the firm wanted to act only for this new client, who was a very, very wealthy corporation, and they didn't want anything getting in the way of acting for this corporation. So what happened? Well, what happened was this. The firm had illness on a particular day of the week. So the partner who was acting for the new firm became very ill, had to go home. And his associate, who was in the middle of an actual trial in this case, needed a signature on a document by the firm. And for the most mundane of reasons, he could not find anyone to sign his documents. So he looked around and thought, oh, there's that old partner in the floor downstairs who no one ever speaks to. I'll go and talk to him and he can sign the documents for me. So he did. And this was a very new associate. He didn't know about the rules which said you're not supposed to speak to that person, because they hadn't bothered to tell him or hadn't bothered to remind him of the importance of this issue. He went downstairs, signed it, got this guy to sign it. This bloke said, oh, I'm not sure if I'm supposed to sign this, but it's all right, I'll just sign my name. It doesn't matter. It's just for a brief court hearing. He went back, the young associate went back and went into court, and by sheer luck came before the judge who had earlier made the order banning that prior partner from having anything to do. So the first thing he sees is that old partner's signature on this current proceeding. And the judge hits the roof, absolutely explodes. And she is a judge when she explodes who you want to stay out of the way of. And completely banned this very powerful law firm in Australia from having anything more to do with this fairly big corporation, losing them millions of dollars in fees. So this got into the law courts eventually because the firm complained about the judge's order. The firm appealed but was rejected on appeal. So it became a precedent. Now, when the big firms say that they can set up an information barrier that will be watertight and will stop anyone from hearing about a case that's current, because our information barriers are very effective, they always forget the mundane problems, the ordinary problems such as illness, or forgetting to keep training up new firm associates in old memory. Old memory of what used to happen is not trained up in the same level. So the most simple things get in the way of so-called watertight information barriers. If anyone wants to read that case, it's called the Optus Networks case, and it's in the New South Wales Court of Appeal, if you're interested. I cite this case only as an example of the phony, false nature of information barriers, because they break down for human reasons, and human reasons are always going to be present in any law firm. So that's what I wanted to start with, that statement, to emphasise that as a profession we have to be cautious of just accepting the views of the big firms that information barriers are effective in stopping conflicts of interest in cases like this. Geraldine, would you like to say something?
Just to follow on, I think the big law firms in every country will now want to act for more than one client. And the reason they use is universal. They say, oh, but Our clients want this firm to act. They don't want to be sent away to somebody else. And we have told them about the risk of us acting, and they have given their consent. And the firm will argue that because the client has consented to them acting, it's now okay for them to do so. And the question I ask is, what did the client consent to? What is the client told when this wonderful consent is obtained? Because I don't believe that if any client realised the extent of the risk to them in their confidential information, sometimes very, very detailed information about their businesses or what they have been doing or their strategy or the way they handle claims against them, whatever it is, I find it hard to believe that if any client realised the extent of the risk of a firm acting against them and for them, they would actually be prepared to allow it to happen. So I'm not a believer, personally, and I think nor is the International Bar Association, in the idea that informed consent is sufficient. And I also am satisfied, and there's a very interesting case which you will be glad to hear I'm not going to read out, but it is a case about a Brunei prince called Prince Jeffrey Bolkiah against KPMG, which is a large accountancy firm worldwide, which I'm sure you have all heard of, which was dealt with in the House of Lords in the UK, and in which the whole area of conflict of interest was raised. And essentially, the position was that KPMG, having acted for Prince Bolkiah in relation to an investment company which he was involved in Brunei, many years later decided to take on a job for the government in which that company was being investigated. And the whole discussion in the House of Lords was about information barriers and what the client was entitled to. And Lord Millett, who gave the unanimous judgment of the House of Lords, said, "The former client cannot be protected completely from accidental or inadvertent disclosure. However, he is entitled to prevent his former solicitors from exposing him to any avoidable risk. This includes the increased risk of the use of the information to his prejudice, arising from the acceptance of instructions to act for another client with an adverse interest, and to use any information in relation to that." So the onus is on the firm to show that there will be no risk. No risk. And the House of Lords said that the risk must be a real one, but it need not be substantial. There is no rule that Chinese walls, which is what they were called in the judgment, do not work. But he said, however, they would be viewed by the court with suspicion. And that has been my experience, just personal to me as opposed to the IBA. I'm a litigation lawyer, and I do quite a lot of negligence insurance work like this. And my experience is that if a law firm has acted for more than one client in the same transaction, or against a former client, and information has been transferred, or there is a risk of the information being transferred, the courts almost automatically assume that there has been malpractice on the part of the law firm. So the onus on the information barriers working, that they work, is extremely high on the lawyer. And contrary to what the large firms argue, most of the bars and best practice across the world would now indicate that, except in exceptional circumstances, there should be no necessity or need for a law firm to act against a former client or for two clients in the same, substantially the same business.
Yeah, I obviously want to reinforce that because this is one of those debates where we're in agreement. The suspicion of the courts all over the world, I think, about these devices, these information barriers, is now so high that any law firm who wants to make a big issue of it is going to spend a lot of money. One of the biggest city firms in London, Freshfields, Derringer, Bruckhaus, which is one of the so-called magic circle firms in London and has enormous millions and millions of dollars of revenue every year, actually fell foul of this itself a few years ago in wanting to act for 2 clients with an information barrier, and despite its best checking procedures, did not pick up that it was, because it was such a big firm, did not pick up that it was acting for both sides at the same time. And by the time they realised that they were acting for both sides, they had spent so much time developing confidential profiles for both these clients that they're in the position where they might not be able to act for either of them and had to withdraw from both sides completely. So instead of starting off with just 1 set of fees, they then go to 2 sets of fees and then they're back to 0 fees. All because the firm was too big and didn't realise that it was in a position of acting for both sides at the same time. And they appealed all of that to the House of Lords, the English House of Lords. The House of Lords just jumped on them from a great height, which is an Australian expression which simply means they were flattened. That was the end of their involvement in that case. Now, Freshfields is big enough to bounce back from that, but it hasn't stopped them at all, just as the Australian firm I told you about hasn't been stopped at all. It's certainly too big to worry. But it hasn't helped its reputation in the short term in either case. So are there any questions from people in relation to these issues? No? Okay.
What I can say that those big firms like Freshfields, they now, because of the potential conflict of interest, have to spend so much time on analyzing whether they have a conflict of interest or not, that some clients have no patience to wait and they just leave and choose a smaller firm just because it's impossible to wait sometimes weeks before they clear conflict of interest.
That's competition between firms, isn't it? You know, the notion is if you've got a smaller firm that's more agile, can move more quickly and can service a client in a situation like that, well, that's good. That's good for the competition between law firms.
Exactly, exactly.
Okay.
Yes, really?
I think unless there's a comment...
well, there is a comment.
Yes, good.
Adrian was quite provocative, but I think that there is one common element here which joins all these problems which you have touched. And this element is probably the major and the only asset which counts in the profession, which is trust of a client. Now, we must not forget that we are acting as lawyers, individual lawyers, but also we are a part of an institution. Now, the institution, in fact, as a body which undertakes a certain position within the structure of the state, is bound to represent society vis-à-vis the establishment of power. Now, we know that every power has a tendency to abuse the power. Now, so our task is to prevent society against abuses, prevent clients' interest against abuses coming from state power, state institutions, but also coming from other players on the market who may exercise their rights in such a way that they abuse it. Now, with a view to have a legitimate title to represent a client or a society vis-à-vis establishment of power, we need to have a trust, because if trust is not there, we have no power of attorney. We are not entitled to act. Now, all these issues, like the fund, compensation fund, which I would say is working in case when client was exposed to a fraud exercised by a lawyer, conflict of interest, lawyers' confidentiality. All these institutions are there to protect the trust, because should there be no trust, we are not really empowered to act. And I would say the funny thing with the conflict of interest issue is that, in fact, if ever we will find ourselves in the conflict of interest position, the burden of proof that we have clean hands is on us. And it is very difficult, I would say then, to bring up sufficient evidence that the trust was not abused by a lawyer. And if we are not capable of doing that, I would say that the only capital which we have as a lawyer, as a law firm, as a profession is gone, which is our goodwill and name.
I couldn't agree more, sir. Thank you.
Thank you, Thomas.
Ну, на самом деле достаточно сложно участвовать в этой дискуссии.
Well, in fact, it's very difficult to participate in your discussion. I'm really willing very much, but it's difficult because examples that you have provided are rather exotic for our country. I've never heard or read a case when our court will judge on the conflict of interests. No, there were. Sergei Pepelev was banned to participate in Yuko's case, but let's say the situation was different. He was writing a book together with the judge. No, that's it. Was slightly different reasons, but the code of ethics is one and the same for all lawyers, for lawyers in large or small firms. In St. Petersburg, we have a number of law firms and companies. Well, and maybe here we can monitor the code of ethics, but we have satellite towns with just one law company, but the demand for legal services is rather high. So how can we act in this case? And the tightness of information barrier will strongly depend on the integrity of individual lawyers. I would like to join my voice to the previous speaker because it's really exotic situation for us. Not so much to discuss this topic, but rather to get a clarification. What a lawyer should do in the situation that I'm going to describe. 2 weeks ago, before the beginning of the hearing, I had about half an hour, and so I was looking at my papers, and I saw two parties leaving the room. And I hear a talk behind my back. The girls are saying that next time we are going to support you and we are going to admit your claims because our client did not pay us. Having heard this, I did not know how to react. The first reaction was disappointment and dismay. Next, I came to the secretary, and I asked what was this case about. Well, to make this story short, I came to the chairman of the court and asked for his advice how to behave in this situation, and he said that I don't know either. So, what would you do? Well, I understand that it's not very frequent situation, but what would be, let's say, the proper behavior, the proper conduct of a lawyer that, let's say, by chance, accidentally, he would get this information? So on the spot, I didn't know how to react, but even now I don't know what would be the right answer to this question.
I hope this is the right answer. I'm not certain. But if what you heard secretly, without anyone really understanding it, is information that's valuable to your client's interests, to your own client, then my view would be that that is information you must use for your client's interests, even though you have come about it without meaning to. And that there is nothing unethical with you doing that if you have come about it in what we call inadvertent disclosure. That's the term we use, inadvertent disclosure. So if you learn that information without any fault on your part, without attempting to learn it, you know, it's happened accidentally, then you may use it for your client's information. And if that means you go to the chairman of the court or to the Bar Association and say there has been a breach of confidentiality here by those people working in that other firm, but I know that my client's interests come first, and I'm going to use it.
Yeah, but as I understand the case, that was not the case where the client of the lady was involved.
Yeah.
It was a third party. So
yeah.
So
I know, but it's not something that our colleague here actually did. She did nothing wrong to learn this information, and once she learns it, she can't pretend she doesn't know it. You can't pretend you don't know it. So you can only use it in your client's interest. You don't owe any duties to the other party.
No,
what do you think?
Well, I think your client was not involved in this case. Is that correct?
No.
No.
Oh, I'm sorry, I did not understand that.
But if I think it's important that if a lawyer knows about another client, at least another lawyer, behaving in a manner which is not consistent with the rules of the bar, that information be brought to the attention of the bar. And this is where a regulated bar with power to enforce ethical standards comes in. We had a case in our country some years ago where a lawyer was actually stole some clients' money, a lot of money from one client. And one of his colleagues had a suspicion that there was something going on, that he was not behaving in a proper fashion. And that colleague did not report him to the bar. And after the money was stolen and the client, the compensation fund paid the client, the colleague who knew felt extremely bad and very guilty, because he said, if I had gone to the bar and reported what I knew at the time, this could have been avoided. And it's very hard sometimes, because if you know the colleague very well, you don't want to be running off to the bar complaining all the time. But if it's something very serious, I think it is justified, and the bar then can investigate. Would you agree?
I'm sorry if I misunderstood you. I agree with Geraldine that you should take the information to the Bar Association. And that applies whether the person you are talking about is a member of the bar or an unregulated lawyer. Perhaps especially if it's an unregulated lawyer, but both.
Yeah, if it is an unregulated lawyer, you go to the judge.
Yeah.
There is no other way, or to the head of court, because you cannot. There is no body where you can complain. It's a problem of the unregulated profession. Thank you.
We now have another couple of topics, and I'd just like some guidance as to whether we keep going or what.
10 more minutes and then... Yeah.
Absolutely.
You're going first.
All right, so this third or a topic that we want to raise is, we think, quite an important one also, and this is the topic of whether lawyers should blow the whistle when a client is defrauding the state. Now, in the West, that mainly refers to tax evasion, where a client is not paying tax and it's clearly a criminal activity. It's not just an interpretation of the law about whether tax is payable or not. So this is clearly a criminal avoidance of tax, or evasion of tax, sorry. So in that case, lawyers do sometimes say that they do not have to go to the tax authorities or to the government and complain about their own client for obvious reasons because of confidentiality. But in most codes, you will find an exception to confidentiality where allowed or required by law. So if law says in nearly every country, and I'd be very surprised if it were not the same in Russia, Vasily, that if anyone is involved in evading tax, then no one is allowed to keep that secret. Is that the case in Russia? Not necessarily? Okay. Okay. Well, that may be a very interesting topic as well, because pretty much all over the rest of the world there is a rule which says that if there is criminal activity going on in relation to tax, then the lawyer must disclose it to the tax authorities, and if the lawyer does not, the lawyer becomes as guilty as the tax evader in failing to pay tax. And so we often face a situation, I think, where as lawyers, if we've got clients who are criminal and we keep quiet about the criminality, then we risk actually being described as criminals ourselves. Now, the point about trust at the back, a very important point, sir, obviously brings itself into this situation as well. But trust can also be trust of a band of criminals, between criminals. We can have trust inside a lawyer-client relationship between the lawyer and the client, where both are involved in breaching trust with each other and with the state. In that situation, I think it's arguable that lawyers should blow the whistle. And I want to say this for a reason. The only thing a modern state has to resist a whole range of problems that the planet has, everything from global warming to pollution to not enough food to feed the country, everything, the only thing the state can do about that is to collect tax and pay that tax for those things. So if we allow our clients, be quiet, Geraldine. So if we allow our clients to actually get away with that criminality, then we're defrauding the people as well as the state as lawyers. So I would argue that in those situations we need to be making sure that we're prepared to blow the whistle. Don't you think, Geraldine?
I do not, Adrian. I have never been so horrified in my life. How could you make such a suggestion? What you are suggesting is in breach of everything that we have been taught as lawyers. The duty of confidentiality to the client, the protection of professional secrecy, and you say that the only thing a modern state has is an ability to collect tax. It also has a huge capacity to have people do this work for them. I'm not a tax collector for the state. I'm representative of my client. And if I'm put in a position where I have to disclose to the state the fact that my client might not have paid €1 million in tax, does it matter if it's €1 million or if it's €10 or if where will we draw the line? if he buys a packet of cigarettes in South America and he doesn't pay tax on them when he comes back into the country? Is this something I have to report to the government? It's outrageous.
Well, it's not outrageous, Geraldine.
It's outrageous, Adrian.
No, you're wrong, Geraldine, because not only are these tax evaders not paying tax, they're also quite corrupt people, and they make us corrupt as well. And not only that, they're usually involved in money laundering and maybe even terrorist financing. And how can we allow all of those things to go on in those people simply because we're too afraid to say something?
Well, I think there is a difference, and I would have to allow that if it's something to do with terrorist financing, or if you realise that your client is about to go off and bring in a big haul of drugs and take the money for that, that may well be slightly different. And indeed, the money laundering legislation in Europe now provides for cases like that. But what you're suggesting here goes way beyond that. And I ask the question, if you have an obligation on lawyers to report the fact that somebody may not have paid tax, then why can't the state extend that to have an obligation to report any breach of any law? For example, if my client is driving a motor car without wearing a seatbelt, that's against the law. Is there any suggestion I'm going to have to report him to the state?
Geraldine, I'm not going to weaken my case by going for those trivial examples that you've mentioned. They're just trivial examples. It's not the same as seatbelts. Whether, in fact, someone doesn't pay tax or not is a fundamental issue of the security of the state, in my view. And the state needs all the protection it can get from multi-billionaires who don't pay enough tax, in my view.
But not when it comes, not to the extent that it undermines the rule of law by breaching probably the most secret of relationships, the most bonded of relationships, and that is the relationship between a lawyer and a client. No client would ever come to us as lawyers for advice if they're afraid that if we tell them something, we're going to report them to the state. That's in breach of everything. It's totally in breach of the lawyer-client relationship.
But a client who thinks that they're going to use the lawyer's secrecy in order to help them undertake criminal activities is just abusing us, is chucking our trust in the garbage, is making us look ridiculous in the eyes of the public. And the trouble is, we are ridiculous in the eyes of the public when we actually aid this criminality.
I don't agree with you. I rest my case.
There are some
I think there are some people who might agree with you, Adrian, one or two.
There was a session at this forum, the legal policy in the 21st century. And I think that obviously the question is there, I would say, what kind of a value we protect, security or liberty? And I think that there is an overwhelming tendency within every political system nowadays in the world that what I have called already as an establishment of power is creepingly enlarging the scope of its penetration. Now, the lawyer should not be an accomplice of a criminal, that is certain. But why a lawyer should delete, whereas within the state we have a plethora of institutions dealing with looking after people, bagging telephones, and in fact investigating crimes. I mean, why should a bar in any given country be requested to be responsible for, I would say, combating crime? I think it is totally wrong. And finally, it will very much affect the liberty of the population. One thing is certain, that all these definitions like terrorism, money laundering, they are very liquid, and it is extremely easy to interpret them too widely and in such a way prosecute, advocate for the very fact that they are exercising their basic social and political function, defending people. And this is, I think, in a way, an exaggeration what happens. The funny thing is that it happens first in the countries and system which we have been viewing as examples of human rights and examples of democracy. And you have both, I would say, England and United States, where all these values, in a way, they are being traded against security. Now, so what will happen in the countries where, I would say, legal tradition is not as strong and as vivid, and whereas, I would say, the abuse of power is even more easy. So I think that at the end of the day, what happens is that we are spoiling the values for which we are really striving for since at least 100 years.
Thank you very much.
Значит, мне кажется, что здесь тоже существует все-таки два аспекта.
I think there are two aspects to the problem, and we have to take care of both aspects. First is when you have a client who come to you and say, well, I have violated the law, I have a criminal case against me, please help me. And of course, you get some facts, you get some information, and the task of lawyers is to minimize the consequences, the problems. There's another aspect, and I have seen cases like that. Here comes a person and says, I want to commit a burglary, for instance. How can I do that without being caught? And that's a different case. I'm a citizen of my country, and I can say that, sorry, I am not ready to help you. Obviously, there's a third aspect. When you have a client coming and says, I want to minimize my taxes. So in a way, it's tax evasion. But the tax legislation states that there are some possibilities to avoid certain taxes. And obviously the lawyer is able to help here if nothing is violated. And I say, okay, you have to pay 500,000 and my client wants to pay 400,000, and so cheat the government out of 100,000. But if the government allows this, then I don't think we should blow the whistle. Well, I mean, tax optimization can be viewed as burglary in a way. I wanted to support what you said at first, but the last phrase, the last situation that you described made me think. I think it's not ethical. It's not even an ethical problem. What Adrian told us, it's possible. Well, the situation was kind of murky a little bit. It could be something about ethics about it. But in this case, the case that you described, from my point of view, has nothing to do with ethics. You can't do that, what you just said. But of course, since I myself have a lot of experience of providing consultancy in criminal cases, I totally support the person who sits behind me, and I support what you said, because lawyers and the bar was established in order to reach a certain objective, and we do it within the law, but obviously the goal sometimes may not, or may be in conflict with the other party, right, with the system. Sometimes we work against the police, sometimes we work against the activities of other government authorities. We are working to defend the liberties and values of citizens, of people. So if we're talking about dilemmas, possibly in some cases, just like Adrian said, in order to be honest, one has to leave the bar. Yes, and do something else. But what you said, what the case that you described, I think this is encouraging criminals. Thank you. Yevgeny Semenyaka, the president of the Russian bar. We're very pleased that you joined us here. Colleagues, friends, we are discussing today a problem. Maybe you should join the panelists here. No, thank you, I will stay here. I just jumped in from a different room. I have another roundtable discussion that I am a participant in, but I was very pleased to join you. I'm very happy that I was able to come even at the end of the discussion. I think ethics is one of the most topical issues. There's nothing more important for our profession today. And obviously, the attitude to ethics determines the future of our profession. It may sound too traditional, too conservative, and maybe I will look as conservative in your eyes, but I believe that our profession should not shy away from the fact that it is one of the oldest professions in the world. Maybe not the oldest, but one of the oldest. And it survived until the 21st century. And obviously, without any doubts, we should be able to maintain the trust of people who come to us for help. And this is only possible when we do this. And I totally agree with my colleague who said that under no circumstances she can agree to what Adrian said, that the interests of security and the interests of the budget and ensuring that the budget has money because the only source of the income is taxes, that's not what's happening. Why lawyers should be involved? Maybe we should talk to the priests. Perhaps priests should be involved in this. After all, there are confessions, and what if people confessed of wrongdoings? And I wanted to grab the mic for one reason alone. I think that I don't want to believe that we have a lot of dishonest people around us, because as you said, if you want to be honest, you should leave the bar. I'm confident that our community, our association has mostly honest lawyers, and people who work in our institutions are honest. But the role that we play is different. Our task is different. The government is a complex body, and there are a lot of different interests. It's in the government's interest to give access to its citizens to legal defense, to legal advice, to healthcare, etc. And the value of our profession is protected and is trusted by everyone, including the state, including the government. We should not undermine these values. We should, because if we do, then the lawyers as an institution will cease to exist. It is impossible to defend citizens without the confidentiality of information, because without confidentiality, the institution of lawyers becomes a fiction, becomes non-existent. And it is more important for the government than the lack of some money that they did not manage to get into their nets. The lawyer happened to know something that they may be related to the collection of taxes. And I apologize for taking so long, but I believe that the problem of confidentiality is not a theoretical problem. It is a practical issue. It is a problem, it is an issue that everybody faces, and that lies in that is a cornerstone of our profession. People who do not want to see this often look at us as accomplices to criminals. Because when the lawyer may or may not be an accomplice to the criminal, that's where the criminal code should be applied. Not ethical codes. But what we discuss right now has nothing to do with a situation where the lawyer is a true accomplice to some criminal activity performed by his client. We're here talking about the morality, or we're talking about true lawyers. And lawyers should understand that their goal, their task, is to serve the people, to serve citizens. The lawyers should know that just like priests have one and only task, to advise and help people. And sometimes it may be associated with the risks of being liable under some criminal cases.
Oh, thank you very much. I think your words are a very good conclusion for our discussion, and thanks for drawing this very concise understanding, and thanks for those who stayed from the very beginning till the very end of our discussions. I would like to express my gratitude to Geraldine, to Adrian, to Elena for really sharing your views on those very interesting topics with us. To sum up, I think that in Russia we need to discuss these matters, to discuss them not only in our closed circles of lawyers, but also to speak with our clients, and best of all to speak with those clients who are in a way ignorant about our code of ethics. As we heard today, many people from corporations have no idea about our plans, our ethical rules, and in this respect, I think we need a kind of awareness-raising program for our clients, not only among the in-house legal counsel, but also for owners and executive staff of corporations. I would like to thank once again everybody for their participation. Thank you very much. And I wind up our session.
Ты трудоголик. Ну, я не трудоголик, я просто...